All right, good morning, everybody. I see that some of our long-distance travelers were able to make it, even despite all of the travel difficulties this morning. And so we're going to go ahead and begin this morning. I know that we also have 3 of our members calling in from afar, I believe in Chicago. In any event, let's start with a roll call, and then we'll talk about where we're going to go today. Mimi?
Justice Edmond?
Here.
Toby Rothschild?
Here.
Joyce Raby?
Here.
Andrew Arruda? Simon Bohem? I don't know how to pronounce his name. Okay. Is he not here? Okay. Tara Bird? Here. Judge Wendy Chang? Abhijit Shaban?
Here.
Jean Clausen? Valerie Dean? Johan Droshagen? Margie Estrada? Lori Gonzalez? Bridget Grammy? Andrew Kuchera? Joanna Mendoza? Kevin Moore? Heather Morse? Daniel Rice? Alan Rodriguez? Daniel Rubens?
Here.
Mark Tuft? Joshua Walker? Thank you.
All right, Let's find out. It was my understanding that Jean Clausen, Lori Gonzalez, and Alan Rodriguez were planning to join us by telephone. Can we ask if they are on the phone?
We are on the phone. I hope you can hear us okay.
Is that Alan?
Alan Rodriguez is here. Lori Gonzalez is here. Jean Clausen is trying to make her way to the room.
Okay, terrific. Thank you very much. You will have to speak up because it's very difficult to hear you. We actually wanted to start this morning with a welcome. We have a new member with us. Johan, you're going to have to say your last name on your own. But we would love to have an opportunity to find out a little bit about you.
Thank you very much. My name is Johan Drolshagen. My company is Brickhouse Security Consulting, and I've created a suite of solutions for things just like what we're here to discuss under the name Level Playing Field Solutions. And I happen to be a member of the bar in Washington State, mostly by accident. I'm not an attorney. I was admitted as an ADR professional, mostly because, again, somewhat ironically, I was trying to attend CLEs, and I wound up having to join in order to attend those CLEs, and actually created an online arbitration platform back in 2009. The last 4 or 5 years, I've actually spent more time on the criminal side, but a lot of the solutions, and certainly the gap exists on that side, and a lot of the solutions are identical for both the civil and criminal sides. And I'm hoping to offer to this group to actually show you some of the things that are available today, not necessarily my own products, but the things that are available out there in the market that can make a very serious dent and move the dial on the access to justice gap. So that's what I'm hoping to offer.
Wonderful. You have a heart that is with the rest of us, and
Yes.
so we welcome you, and we're just delighted to have you
Thank
part of the group. We also have another new member, Simon. I'm not sure how to pronounce his last name either, Bohem, I believe. He actually is traveling, was going to try to call in. I don't know if he has been able to make it or not. The next item on the agenda is actually a call for public comment. So in the event, we were not able to post his location. I believe he's in China. And so if in the event he happens to be on the phone, we are now opening this up for public comment, and he could let us know that he's participating. Otherwise, we will reserve his opportunity to introduce himself for the next meeting. So let me, at this point, call for public comment. Is there anyone who's participating either here, live, or on the phone that would like to give public comment?
Yeah, hi, this is Drew Amerson. I'm in Chicago. Can you hear me?
Yes.
Great. So I'm actually
Drew, could you please spell your first and last name?
Happy to. It's Drew, D-R-E-W, Amerson is like Emerson, but starts with an A. Amerson.
Thank you so much.
Yeah, so I am actually the director of a Center on Law and Technology at UC Hastings, and was out here for the ABA Tech Show and just wanted to sit in and learn more about this process. I guess I'll keep my comment brief. One of the things I do is I run an accelerator program at UC Hastings for outside legal tech companies, and as I've been developing that, I've gotten a lot of questions surrounding the things you're taking a look at, around UPL issues, around fee sharing, and I think that the work you're doing here is really important, and we'll be keeping an eye on it, and thank you all so much.
Wonderful. Thank you so much for participating, and hopefully you'll continue to do so as we proceed down this path. Anybody else that wants to weigh in with public comment?
This is Jason Richmond. I'm calling from California, and I'm with a company, Live Litigation. I was actually introduced to the group just a few days ago from Jason Lee. Found myself in a meeting with him on another project. And what we've been doing for the last decade, and most of you probably haven't heard of us, which is kind of the reason for me joining this call, is we've been providing technology that greatly decreases the cost for litigation. And this is something that's been sold through about 200 court reporting agencies. But really my question is, and how I'm hoping to maybe assist, is how to get the state bar and other agencies to increase the exposure of these types of technologies to help reduce legal costs just to the general public, and not have it just affordable to, you know, the higher price clients who want to utilize it. So excited to hear what you guys have planned and see if there's anything I might be able to add to the discussion.
Wonderful. Thank you so much for participating. Anybody else who wants to weigh in with public comment? All right, hearing none, let's talk just for a few minutes about what we're going to be doing today. As you can see from the agenda, we're going to start with the chair's report. There are a couple of items that we want to discuss. I'm actually going to turn the floor over to Randy to discuss those items. But then after Randy covers that, there's going to be a staff report on social media guidelines. Hopefully you were able to download, or you have your computer so that you can see some social media guidelines that have been developed by staff for our use. One action item is the approval of the summary of the last meeting. And then we're hoping to get all of that business completed by around 11 o'clock so that we can break again into our subcommittees. And so we will break from 11 to 2 into the 3 subcommittees. And Mimi will let us know when that time comes where each committee will meet. The folks from Chicago, if you're going to still be participating, we'll need to make sure that the subcommittees have you on the phone in their particular room. By 2, that we'll do lunch just like we did last time. Whenever it's a convenient time for your group to break, or, you know, anytime between 12 and 1, you can take a break for lunch. We expect lunch will be around a half hour or so, or you can have a working lunch at your table, whatever works best for your committee. And then at 2 o'clock, we'll get back together and we'll have the same sort of session that we did last time with the debrief from all 3 committees, with somebody reporting out from each of the subcommittees, and with obviously contribution, opening it to the floor for anybody who wants to comment or discuss what's happened in the subcommittees. We'll plan to break by around 4:30 this afternoon. So let's go back to the chair's report. There were 2 particular items that we wanted to talk about. And these are items that sort of we've heard from all of you on. The one issue is speakers, and a desire to reach out and hear from other people who specialize in the various areas that we're touching on. I know everybody really enjoyed the very first meeting that we had, when we did have some really interesting and informative speakers come in. And so many of you, Bridget and others, have been giving us names of people that they think would be helpful. And so the first thing we want to talk about is potential speakers for future meetings. The second issue is going to be One other thing that we, the leadership and staff, heard last time was some concern about the fact that there's a fair amount of overlap in the discussion among the various subcommittees on a variety of topics. And is it better to get together in one big group than to have separate subcommittees addressing these issues? And so that's another thing we want to talk about, is sort of the plan on how we should be addressing these issues going forward, and the format. Welcome.
Thank you. Sorry.
Rough travel day, huh?
A little rough. Green layer.
Okay. So on that note, I'm going to turn this over to Randy to address those two issues.
Good morning. Starting with the issue of speakers. And so leadership and staff met and we looked at our current calendar of meetings. And we think there are two things we can do to accommodate hearing more information from other experts to inform the development of concepts for a report and recommendation. The two opportunities that we're envisioning are: one, on our calendar, we have a meeting scheduled for April 8th. It's actually our next meeting. It's going to be in San Francisco. And we're thinking, if we can work it out, we might be able to invite one or two speakers who can provide us information that will inform and enable us to develop our report and recommendation, the concepts for reform that we're considering, addressing some of the issues that we might feel are outstanding and where we don't have resident expertise around the table. And so we will be looking at possibly two speakers in April. And if you knew of someone who fit that profile, we've already had some folks suggested to us. I'll just give one example. Margaret Hagan from Stanford was referred by Bridget, who is a human-centered design specialist. And so if we're going to be designing possible online products or services or applications for legal information or an actual substitute for a lawyer's advice, then we'd want to have those types of concepts in mind in whatever regulatory reform that we're proposing. And so a person like Margaret Hagan from Stanford might be a likely choice to bring before us in April as we develop our recommendation. We also have a number of other people who have been referred to us, and some of them we think might be actually folks who can give us constructive feedback on whatever concepts and recommendations that we do develop, and which we're due to finalize really in tentative form by our June 28th meeting so that the Board of Trustees can issue it for public comment at their meeting in July. And so we have this hiatus time period after our June meeting until we're supposed to meet again on our calendar at October 7th. And what we have decided is that we'd like to see if we can schedule an August meeting. And the August meeting would be a meeting dedicated to receiving input from additional speakers. And also, if the timing works out, we would like to have the survey completed so that we can also review the survey responses at that time, so that when we come back together in October, we're not sort of double burdened with having to look at the public comment received, and on top of that, the data from the survey, and trying to accommodate all of that in reassessing the tentative recommendations in our proposed report. And so an August meeting will help us in two respects. It'll possibly, if the timing is right, give us an opportunity to get a head start on the survey data that comes in, and also give us another opportunity to hear from speakers. Again, these would be speakers who you think would be able to give us some fine input on whatever recommendations we come up with. And we're thinking if it's a day-long meeting, it could be 2, 3, 4, maybe more, but we'll see. And the other proposal is just something that came up this morning. We don't know how much we can talk about it today, but in August in San Francisco, the ABA will be holding its annual meeting. And at the same time as the ABA holds its annual meeting, the Association of Professional Responsibility Lawyers will also be in San Francisco for their meeting. And I think we've mentioned before that the group April has its own multi-member group that is studying technology and access to justice. And so we're exploring the idea of having a second date in August, possibly August 10th, which is a Saturday, because April meets, I guess, on Saturday morning. and Saturday afternoon might be available for something that might be, I don't know if it's a public comment session that we would call it, or a town hall meeting, or a roundtable of summit of some sort. But many members of this group have been approached by others who are engaged in similar studies. Joyce was telling us about, was it Utah?
Utah and Arizona.
Utah and Arizona have approached Joyce directly saying, hey, can we combine our forces, our thinking, and maybe improve each other in terms of what we're doing in the same space? And so a lot of things align when you have the ABA in town in San Francisco, both ABA folks, April, and I think NOBC, often National Organization of Bar Council, mentions at the same time as well. And so if we are able to work out August 10th as a date, either some sort of public hearing session or roundtable or town hall meeting, whatever we call it, then we would be able to have this interaction with these representatives of other studies. They can learn what we're doing, what we're thinking, and we can also benefit from them. And because we wouldn't be looking to take action, it's not like we're working on our survey responses or hearing from speakers. It wouldn't necessarily be all hands on deck. If you weren't planning to come to the ABA annual meeting, or April, or NOBC in August in San Francisco, we wouldn't be looking for full attendance. We wouldn't be taking action, so I don't think we would need a quorum. We just wanted an opportunity. Actually, we didn't want to have a missed opportunity to have all those folks in San Francisco, potentially people working on these same issues, and not be able to knock heads with them, brainstorm with them, and benefit from their good ideas and share what we're thinking as well. And so those two things, look for further contact from staff about possibly August 10th to coincide with the ABA, with the primary goal of getting together with other states who are doing these same studies. And then another date in August, which would be our actual meeting date, which would be focused on speakers and also hopefully reviewing the survey data. And I will give you some dates that coincide with meeting space at our San Francisco office, if you can just jot them down. August 1st, which is a Thursday. August 2nd, which is a Friday. August 5th, which is a Monday. August 6th, Tuesday. August 8th, Thursday. August 9th, Friday. 20th, Tuesday. 26th, Monday. 27th, Tuesday. And Friday the 30th. If you know you're on your family vacation that you've planned for the whole year, or you've got, a business retreat or something, and you absolutely cannot make any of those dates, please send an email to Lauren and we will take that into consideration. But we do have our chair available. We do have meeting space in San Francisco. So that is really our starting point for having that meeting again, a meeting to consider hopefully the survey results, as well as to hear from some speakers. And if you have ideas for speakers, again, in April, we're trying to line up maybe 2 people who would help us think about our recommendations. Please send those names. And if you have a link to a bio, please send that to Lauren as well. And if you think you have someone and you haven't already submitted a name, just someone you think would be interesting to hear from present to the task force, or in particular, someone who could analyze what we're recommending and give us constructive criticism and feedback, I mean, that would be my first choice, because that's why we have a public comment period. Then that would be great as well. Send those names, and if you have a link to a bio, to Lauren. And that's all we have on speakers. If you have a name right now,
We got
that
Kevin
you
with his
wanna-
hand up.
Oh, sure.
I don't have a name, but I'm assuming that you're not going to put the burden on us to remember to send that information into Lauren, that Lauren will send out an email to us with those dates listed. and
That's fine,
ask us
yes.
to identify. Okay,
Sure.
thank you.
And I have in terms of the April
Hi.
meeting, in terms of speakers, one of the things you said is that the concept was really to help us develop ideas and things that we have going on. Are you interested in having demonstrations of existing software, tools? I mean, I can think of a couple of examples in Canada. I can think of a couple of examples my organization has put together. We've got clearly some people here on the committee that have some software, and I just don't know if you're thinking in terms of actually looking at some of these tools and some of these ideas in action.
I'm open to it. I think it's the chair's pleasure in terms
I-
of the type of information we gather in these sessions.
I would suggest that you, what we're hoping for is that everybody puts this into an email and sends it to Lauren. I would definitely make that suggestion, and it'll be one of the things that we consider. Unfortunately, obviously, we've got a limited amount of time and want to continue to make progress because we've got all these deadlines coming up. But at the same time, certainly, at some point, it would be, I think, very useful to have that sort of a presentation. And the question is it come before we do what we do or after? And so, but gathering that information is very helpful. Yeah.
Alan Rodriguez on the phone.
Sorry, it might also be helpful if we could get
Alan,
demo.
just hang on one second. Go ahead, and then Alan, then we'll turn to you, Alan.
If we could get demo accounts for some of these products that were maybe we can't sit here and I'll do it. I found that very helpful because I think it's nice to just play with it and see what it looks like.
Okay, Alan.
I think we should, in terms of speakers, I think we should include John and Jane Doe. If the product guy in me says if we're designing products for the end user, the consumer, they should have a seat at the table. And so hearing from people who received either inadequate or no legal assistance, right, and hearing from the end user ultimately who's going to consume the legal service, I think would be valuable product design information. So to the degree that we can reach out to organizations that are trying to help to fill the A to J gap, and hearing from actual customer voices and the struggles and the pain points that they go through, I think would be invaluable for us to design a system that works for them.
Okay, thank you. And again, everybody, we really appreciate these ideas here today, and I think we should talk about it, but please do follow up with an email to Lauren so that we can gather all these suggestions. To the ATILS email box. Thank you. Okay. Any further discussion on this issue of speakers? Leah, did you want to weigh in?
Well, I have suggested to Randy that we invite Rebecca Sandifer. I thought I believe the recent report was shared with all of you, and I think it's really powerful and directly on point. So hopefully we'll be able to get her here.
She's definitely on the list. Okay, Randy, you want to talk about the crossover issues?
Yes, and so leadership and staff did have a meeting about the discussion of issues that are crossing over, if you will, between subcommittees. And if you recall back at the January meeting, we introduced the subcommittee strategy as something that was designed to align with the actual charter from the board. So I don't know if we have the charter that we can put up on the screen right now. But the charter really has 3 enumerated components. The first one is that we're supposed to review the current consumer protection purposes of the prohibitions against UPL and the impact of those prohibitions on access to legal services with the goal of identifying changes that might increase access while also protecting the public. We're supposed to look at the definition of the practice of law and how that interplays with artificial intelligence and other technology or online delivery systems. The second part of the charter is that we're supposed to evaluate existing rules, statutes, ethics opinions on lawyer advertising and other professional responsibility issues to determine, the purpose of those long-standing public protection standards and whether or not there could be changes in those standards that might foster innovation or expand delivery of legal services. So a focus on existing law in California, rules, statutes, ethics opinions. And the third section of the board's charter was a focus on preserving client protection, but also exploring other business formats for a delivery system. And so the acronym of ABS for alternative business structures, or sometimes alternative business systems, and MDP for what was the old or original idea of multidisciplinary practice. And with that topic, in the charter is actually interest in permitting non-lawyer ownership or investment, and whether those are things that would facilitate the use of technology in delivering legal services. And so we have 3 subcommittees that are supposed to help us write the sections of those reports and come up with the proposals that align with those particular issues, but we did recognize that there are things that cross over. Just looking at the materials for this meeting, you will note that the AI UPL subcommittee has received a wonderful memorandum that is talking about the data security, the encryption requirements, the other level of technology sophistication and assessment of those criteria. If ATILS were to recommend the reform of entity regulation and an entity that would be authorized to deliver legal services, to practice law, and enjoy safe harbor from unauthorized practice of law. At the same time, you have the ABS MDP subcommittee looking at Model Rule 5.7 as one step towards describing a situation where a lawyer's might be, or a law firm might be, an owner of an ancillary business or non-legal service that might be delivering law-related or legal services. We also see in the materials for the Rules and Ethics Opinion Subcommittee the impact of these rules on what might be, again, an entity regulation model. And so it's clear that there is a coalescing of minds on a principal reform that might be the main feature of our report and recommendation, and that is an entity regulation model. But I'm hoping that we can sort of stay in our lanes for at least this meeting and the next meeting before we venture off onto the same highway and join together and try to integrate all of these parts. Because I think what we see is if AI-UPL continues its focus on what are really the technology aspects of what this licensed or regulated or certified or registered entity might be, and the ABS MTP continues its focus on the business format. At the last meeting, they reported out their consensus that we don't think it should be MDP because MDP has as one of its inherent features this idea of the collaboration of licensed professionals. And we're looking beyond that at this point. Technologists, entrepreneurs are not accountants, they're not medical doctors, they're not licensed professionals. But we think that's where the combination can come in. And so they are pursuing their part of the charter to describe, again, what is the business structure format of this potential entity that would be delivering legal services through technology. And I think they will be continuing to refine that as we go along. And so I would want them to be able to do that without worrying about data security or encryption or any of those standards. And I would want AI-UPL to be able to further refine their part of the puzzle without worrying about the business structure. And so I think there are still things that, for example, ABS MTP still needs to do on their own. We still need to talk about whether or not there should be non-lawyer ownership. Well, we have to talk about whether that non-lawyer ownership can be just passive investment. We have to talk about exactly what structure of the entity. We have the UK model. We have the old MDP protection of core value model, which was largely a command and control issue. But those things remain to be fleshed out. And I think over the course of this breakout session and the breakout sessions we have in April, if those are all advanced, then when we come together, we can have a much longer plenary session with everybody so that if there are ideas that cross over, we will be integrating them together in a comprehensive, combined recommendation. Again, I don't want to get too far ahead, but I see entity regulation as what this committee, this group is recommending. And so if we put the different aspects of entity regulation together, I think that will form really the main thrust of our tentative report and recommendation. The Rules Subcommittee staff has provided a nice little tracking chart for you because you've already started it and you're marching right down. And as you continue to do that, you can assume, I guess at this standpoint, that there will be some sort of entity model. And if there are amendments to the black letter, to the comment, or an ethics opinion that might be useful in improving those rules, changing those rules so that they can facilitate entity regulation in a model that entity is almost like another lawyer that you're allowed to partner with, to share fees with, that wouldn't be interfering with independent professional judgment, then I think that's appropriate for that subcommittee. So I think, again, each subcommittee still has some things that will be needed to finish off their charter. Now, there will be some crossover issues where you want individuals from each subcommittee to work together, and we did that over the course of the time from the last meeting to this meeting. Professor Moore and Andrew were able to work together on a report on 5.7. And if there's definitely a burning issue that subcommittees want to work together on between meetings, if you just coordinate it with staff and you keep it limited, we only had 2 members working together, we won't run into any Bagley-Keene issues. So if there is something that comes up that definitely is crossing over that you want to work on together, coordinate it through staff, and same way we helped Andrew and Professor Moore work together, we will help you guys get together as well outside of the meetings. And today I won't be sitting in on one subcommittee meeting. I will go to each of your subcommittee meetings today and try to play traffic cop and keep people in their lane. So if you have any further questions about anything coming up in your agenda, worried that it's going to be missing out on some good input from another committee's recommendations and study, then I will be the one to try to manage that collaboration if it's needed, or try to refine where I think the relative areas of study ought to be focused on within each subcommittee. And that's all I have on both speakers and crossover issues.
Okay, so you'll have an opportunity to grill Randy in your subcommittee meeting. But is there anything that anybody wants to say now, either comment or question, on the issue of crossover topics? Okay, at this point, we're going to move on. Oh, I'm sorry. Somebody on the phone?
No, I'm sorry.
Johan.
It was me down here at the end.
Yes.
I promise I've watched both videos, and I've read every bit that has been shared with me in the last 3 weeks.
Which is no small task.
No small task at all. So I guess what the one question I have that I didn't gain from that you just touched on is, what is the jurisdiction as it stands today with regard to anyone or anything other than a licensed legal professional? Does the bar have jurisdiction over firms? Does the bar currently have jurisdiction over technology firms that do this? I'm wondering if we are starting from purely a recommendation standpoint of what we'd like to suggest be jurisdiction, or what jurisdiction do we actually have in the letter of the law today, if I may.
How much time do you have?
Yeah.
Okay, so if you looked at the board's charter,
Yes.
it covers practice of law regulations, which are largely statutory, but there are also exceptions in the rules of court. And we use that at our first meeting as our model, the issue of multi-jurisdictional practice, lawyers from other states being allowed in a limited fashion to practice law in California. And that was done through a special advisory task force of the Supreme Court. And I think in the same way, that body was allowed to make recommendations concerning who or what would be entitled to practice law in California and what ought to be the public protection rules and standards applicable to that practice. I think that is fully within the, as you put it, jurisdiction of this task force to recommend. It doesn't mean that the state bar by itself has the implementation ability on anything we might recommend. There might be things, rules of the state bar, but even a change to the rules of professional conduct would simply be a board adoption with a direction that it be submitted to the Supreme Court for approval. And the practice of law prohibitions, the remedies for violations, all of that is statutory. And so that might mean partnering with the legislature to consider statutory revisions to implement these recommendations. But we are really focused, let me just say, we're focused on the concepts of reform. A more nimble body will probably get the assignment to do the heavy lifting in terms of actual red line strikeout versions of new rules or statutory changes. We really need to focus on what is the concept of a regular reform that might touch and concern changes to practice of law, rules of professional conduct, et cetera.
Randy, I didn't hear you answer the first part of the question, which is the current scope of the State Bar's regulatory authority.
Sure.
Do you want to just?
Yeah, we don't have Judge Chang. She wrote a wonderful memo. I don't know if you've had a chance to read it. She submitted it for the last meeting on the current regulations of the practice of law. And there is a doctrine known as the Corporation Practicing Law Doctrine that is alive and well in California. And so, of course, the only persons, natural persons who are allowed to practice the law are people who are authorized to practice by statute or rule of court. And those include people who passed the admission process, but it's not just them. I just mentioned that there's multi-jurisdictional practitioners. So a person who's licensed in New York, who's never taken the California bar, can actually be an in-house counsel here in California pursuant to applicable standards in the state bar rules and the rules of court. A law corporation, if they're formed under the Professional Corporation Act, certified as a certified law corporation by SPAR, that corporation is allowed to practice law and have revenue and profits from the practice of law. Mark submitted for this meeting the statutory scheme that pertains to nonprofit corporations being allowed to practice the law, and that keyed off some statutory provisions as well as a Supreme Court case called Fry versus Tenderloin Housing Clinic. And so the practice of law, you shouldn't simply look at it as if you're not a member, you're frozen out. There are other things, persons, entities allowed to practice law, and we can conceive of things that fit that model or are completely revolutionary in terms of how we want to pursue it. I'll mention my own plug that I submitted for this agenda, a memo on legal advice device regulation. So maybe it's not even regulating a provider. Maybe it's regulating the product itself. But I just wanted to open the minds of this task force to all the possibilities and to also give an example of if you want to define a reform, you need to have a concept that sort of lays out how it starts, how it ends, and what's the benefit of it in the end. And I hope that answers the question.
And we're presuming regulation for all of that.
The concept of what would need to change, not exactly wordsmithing or developing the actual changes.
Right now, the State Bar does not regulate law firms.
Right.
We don't regulate legal technology providers. Right. Really, our regulatory authority is very focused on the individual attorney, and then to a limited extent, LLPs and LLCs with registration requirements.
Perfect. That's what I was looking for. Thank you.
Okay, on that note, let's move to, we've got an item on our agenda, which is a staff report relating to social media guidelines. Hopefully you had a chance to look at some proposed guidelines that were in the materials. And Mia, are you who's speaking on this?
Teresa Ruano, our
Teresa,
media consultant.
thank you.
So the guidelines that we've created with staff are responsive to, I think, some questions that came up during the first meeting in which this group received its briefing about the Open Meetings Act and what it means to the work that you do. And because of the focus of the membership here, so many of you are active online and do bring your relationships and your networks as a part of what you bring to this group. And because some of the members have since joined the group, what we've tried to do is to summarize how you can actually use your social media relationships to support outreach and to support engagement with the public without creating problems that have to do with transparency under the law, under the Open Meetings Act. And I'm not a lawyer, but I think the main point is that the Open Meetings Act is as much about how you interact with each other as it is about how you interact with the public. So by all means, share on social media, crowdsource on social media, but just do it with a mind that it needs to be within the rules having to do with making sure that the work of the task force and the decision-making processes are open and transparent. So if you have questions that are specific, I'm not a lawyer, but there are excellent counsels as a part of your staff, so the best thing to do is to refer them to staff. And if the communications office needs to be involved, we absolutely will. So any questions now?
Let me just.
Donna?
Yeah, so I just wanted to add, I mean, I think the key point here is we want you, those of you who are on social media all the time, we encourage you to share the work that we're doing, to get input and ideas from the people that you communicate with, that you follow, that follow you on social media. The concern is just you following one another and you communicating with one another. Because we don't want to inadvertently sort of create a meeting by you communicating with one another. We end up with a majority of the committee responding to each other, and there we have a problem. But if you are putting information out there about what's going on, seeking input, hey, what do you think about this? Is this a good idea? Is this a horrible idea? Sort of however you would normally communicate. If you're getting input, you can bring that input back to the group. It's just a matter of making sure that you're all not commenting on each other's posts. So that would be the sort of the biggest caution is don't comment on one another's posts, and then we can use social media as a tool to get wider input on the work that we're doing.
So as I understand what you just said, a lot of what you focus on is on the top of the sort of the second page is don't create a serial meeting by responding to, commenting on, or retweeting other committee members on social media platforms. Similarly, I think it says don't tag or mention other task force members in your posts. So we're just trying to keep from having an informal meeting be created by talking to each other. Kevin?
So, just as a clarification, if I were to follow someone, and I don't imagine I ever will, but if I were, so long as I passively sit back and listen or read what they're tweeting, is that the word? Yes, okay. It's okay. It's just when I respond, that's the problem. Okay, thank you.
Did somebody have a question on the phone or a comment?
Not shockingly, this is Lori who has a question, or kind of a sort of a question. The social media policy was really helpful, and I'm assuming, because I was pretty active this last month, that if we are doing something that isn't fitting within the guidelines, we'll get some direct feedback from one of the staff members. One of the things that I'm not sure of is if we should be tagging the State Bar of California. I know we can use the hashtag, but can we tag the State Bar of California when we're actually referencing our questions or the work? And secondly, I'm assuming y'all will tell me when I screw it up.
Yes, you can tag the State Bar of California, and we will tell you if you screwed up if we see it. So Mimi, is somebody following Lori? So we'll know. Yes, so we are following. So we will let you know if we see something that makes us concerned.
Randy.
And if you are a follower and you're doing exactly what Professor Moore did, just passively watching, but you see something that inspires you to want to comment and you don't want to run afoul of these limitations, type up your information, your comment, send it to the ATILS box with a request that we share it with either your subcommittee or the person who made the post, or to the full ATILS. If you think, hey, someone just said something that is brilliant and I want to acknowledge that and I want to share it with the entire task force, don't be tempted to respond in that medium. Send it to the ATILS box and we will deliver it to everybody for you.
Thank you, Teresa. Any other questions, comments, issues with respect to social media? Joshua.
It's actually more related to Randy's earlier comments, but it's also social media related. There's a few different ways to get feedback to this group from the outside, and the workshop comment I think is well taken about getting users to talk about what they've been through and how they can be better served. We can get people to talk to us, broadcast to us, We can also get the feedback from the public, of course. It is also possible for us to go out individually and communicating into this as per protocol, and to actually go, whether it's to universities or other open public fora, and actually ask people to workshop ideas. So again, I don't know whether that's a good idea or not. I just wanted to mention it as a possibility to send us out, not as envoys, perhaps completely unofficially, but if we can go to universities and get feedback from actively solicit feedback about some ideas from different people around the state, that might be helpful too.
Good. Kevin.
That just leads me to ask another question. If I were on a panel, CLE panel, that wanted to talk about this, and there was another member of this task force on the panel, or two other members, would that be a meeting? If we're just talking to an audience, as opposed to discussing the pluses and minuses or the advantages or disadvantages?
Maybe Brady, our representative from the Office of General Counsel, can provide some observations on that.
Sure. In the scenario you're describing, it sounds like there would not be a Bagley-Keene violation, because that, of course, is when there's a majority of the group present and commenting and participating in the communication outside of a noticed meeting. So unless you three were members of the same subcommittee and discussing the work before the subcommittee, that might lead to a problem. So if you find yourself in a situation like that where you and multiple members of this group are going to be discussing things potentially, you should run it by staff, and we can make sure that there's no issue.
Was there a question or comment from somebody on the phone?
Yes, this is Jean Clausen, and it's more of a suggestion or a question in regards to when we were speaking about the universities, and this is a little off the social media path, but I didn't want to let it go. Since we need a parking lot, that's fine as well. I was actually at Chicago Kent Law School yesterday, and a law student came up to me and asked and recommended if the task force would entertain having an actual law student as part of the committee to get that future perspective of the people that will be having to follow any of the rules or new ideas or solutions that we're putting in place for the future.
Thank you, Jean. That's a really interesting suggestion, and we will definitely put it on our list of things to keep in mind.
Thanks.
And thank you again, folks in Chicago, for taking the time to participate in this. We really appreciate your joining us. Okay, it is 11 o'clock. I think we have one more action item, which is the approval of the January 18, 2019 meeting summary that was in your materials. Is there a motion to approve?
Sorry, Mimi raised that she spotted a typo in referring to the year 2018 for the January meeting. It was actually this year. So if you want to have that scrivener error corrected as part of your motion, that would be welcome.
I take it that's a friendly amendment? Okay, is there a second? Please. Thank you very much, Daniel. Okay. It's my understanding that because we have some people participating from afar and some people in the room, that we need to take a roll call vote on any vote that we take today. So, Mimi?
All right. Andrew Ruda? Yes, no, abstain. Simon Bone? Tara Bird? Judge Wendy Chang? Abhijit Shaban? Jean Clausen?
Yes.
Valerie Dean? Johan Drolshagen?
Yes.
Margie Estrada? Lori Gonzalez?
Yes.
Bridget Grammy?
Yes.
Andrew Kuchera?
Yes.
Joanna Mendoza?
Yes.
Kevin Moore?
Yes.
Heather Morse?
Yes.
Joyce Raby?
Yes.
Daniel Rice? Toby Rothschild?
Yes.
Alan Rodriguez?
Yes.
Daniel Rubens? Mark Tuft? Joshua Walker? Thank you.
All right, anything else for the good of the order before we break up into our subcommittees? Mimi's going to tell us where we're going to go for the subcommittees, but before we break up, let me just say my thanks for all of the work that went into this meeting. I mean, there were some really remarkable work product that was generated. We have so much to read for these meetings, and we really, really appreciate all the time that was spent. Mimi, so tell us where each one of the subcommittees is going to go.
Before we do that, would it be possible also just to give a little bit additional guidance as to what the overall goal by the end of the day you'd like to see from all three subcommittees? I think that is something that it would be extremely helpful.
I think at the end of the day, when we come back, we will talk about sort of what progress has been made by each of the committees on their topics. If you have anything that looks like an action item, we would encourage you to bring it to the group, because the more progress that we can make at each of these meetings, the better. I'm not 100% sure that any group is quite ready to do that yet, but I mean, so the answer is we're not really expecting a lot of action items, but if you happen to have any that you would like the entire group to approve, have at it, and we welcome that. I mean, one of the things for example, we talked about, there was a fair amount of material on 5.7, and it may be by the end of the day that there's a recommendation about where we go with 5.7, and if there is, that's terrific, and we would welcome that. If there's not, we fully understand. So that's sort of how we would approach the day. Kevin, did you want to add anything? Oh, I didn't know if this was. Okay, thank you very much, Andrew, for that. Anybody else? Okay, Mimi.
Okay, the Rules Subcommittee will be in room 2G, which is to the right when you exit out the doors. It's the last room on the right. And then the ABS MDP will be down the hall. It'll be the room closest to the elevators on the left in 2A. And then UPL and AI stays here.
Okay, thank you all. We'll see you at 2 o'clock. How are you?
Good, how are you?
Good.
Good morning. Welcome to our second item on agenda today on the Task Force for Access to Innovation of Legal Services. This is the Subcommittee on Unauthorized Practice of Law and Artificial Intelligence. And my name is Abhijit Chavan, I'm the chair, and co-chair is Judge Wendy Chang, and we will start with a roll call.
Sure. Abhijit Chavan.
Present.
Abhijit Chavan, present.
Present.
Judge Wendy Chang.
Present.
Simon Bohm. Margie Estrada. Heather Morse.
Present.
Daniel Rubens.
Present.
And Joshua Walker.
Present.
And we have a quorum.
Next item on the agenda is a call for public comment. Do we have any public comments? Okay, we'll move on to the next item, which is the chair's report. So at our last meeting, we discussed various aspects of UPL and artificial intelligence, and these are in the minutes for the previous meeting. We will continue a discussion today on after reviewing the assignments that we had assigned at the previous meeting. So that would be later on in this meeting. We'll have a presentation on the report on the assignments by Joshua Walker and Daniel Rubens.
So Brady should first, we should vote on the action summaries.
Okay, all right.
Should we wait? Do you want to do that now, or should we wait until after the staff report?
Oh, okay. Well, we can
Okay,
wait.
so we'll move on to the staff report then? Okay.
So I believe Randy was going to, according to the agenda, present on, or at least it's been placed on the agenda, your legal advice memo.
I'll stand down in that and defer, and let the other reports that were submitted more timely than mine be taken up first. And if there's time at the end, I'm happy to describe it. Again, it's really just for sparking brainstorming,
okay.
And also to give you sort of an example of the kind of description at the concept level, at the forest level, of any reform proposal.
So then probably move on next to asking for a motion and second for approval of the action summary from the January 18th meeting.
So moving on to the approval of action summary from the previous meeting from Jan 18th.
So moved.
Second?
Seconded.
Okay, it's action summary is approved. Okay. Okay.
Brady, you could ask, since everyone was here for the roll call, to substitute the roll call vote.
Oh, so substitute a roll call vote. In other words, everyone in favor of approving the action summary for the January 18th meeting. Oh, does anyone object?
Any objections? It's approved. Let's move on to the next item, which is the presentation and discussion of results from the assignments of from the January 18th meeting. So for that, I'll call on Daniel Rubens to present the assignments.
Okay. So first off, I apologize for this being so long. The appendices probably were not needed, so I killed a few extra trees there. I think at a high level, this mirrors what we were talking about and then fills in a few of the details, specifically around the standards that for security and privacy, and then relates that to specific ethical standards. Keep in mind, I'm not a lawyer,
totally be getting a lot of this wrong, because this is quite honestly the first time that I've really dived into ethical standards for lawyers. So this was fun for me, weirdly. You know, we all have our thing. So at a high level, one of the really core things about lawyers, you know, sort of approval to practice and licensure, is making sure that they're competent. So we can do that in a couple different ways. For algorithms, we can look at how the algorithms perform, and we can also make sure that a licensed attorney is working with the team and sort of overseeing what they're doing. And I think there's an existing model for this under attorney supervision, except in this case it's supervising an algorithm and making sure that it's producing reasonable sort of results. I think of that, because of human scalability, as more of a gut check rather than sort of proper supervision, just because the difference in scale that comes with technology. You can much easier test for every possible permutation in an automated fashion than having a human do that. So a human can, you know, the human lawyer can spot check things, and I think that provides some oversight. But really, the useful metrics that are going to come out of this are metrics that might be something like area under a curve, or an F1 score, or, you know, whatever's sort of academically accepted for whatever algorithm you're using in the sort of scientific literature. So for natural language, yeah.
So just to reinforce that, and you have to remember there are a lot of technical metrics for things, just in the same way there's a lot of metrics for, you know, measuring how fast somebody runs or something like that. A lot of the lawyer metrics, in terms of the IBM versus Kasparov type stuff, can be bunk.
Yeah.
Right? So you have to be very, very wary of things that are saying, you know, this does something faster than the lawyer, or whatever. Very specifically, it's almost a red flag. But there may be things we can do to measure that are useful elements that doesn't remove the need for human discretion to determine whether something is quote unquote competent or not. Sorry for interrupting, Dan.
Yeah, no, that's great. So I think one instance that I'm aware of with this is actually one of our competitors that will go unnamed, published a study saying that, you know, their algorithm outperformed lawyers by some percentage. Well, there were a lot of problems in study design. So that's specifically why I sort of put in, you know, you need to be thinking about this in the context that it would be accepted by a scientific journal.
Can I just reinforce that? So I don't have a conflict on that one, and the study you're referring to had maybe false advertising problems as well. So there were some pretty serious issues with it.
Yeah.
Okay, I have a question, because I'm sorry. I think I kind of understand what you're saying, but I don't feel like I have a real comfort level with what you're saying. So, algorithm review up to a level that's industry accepted. I get that.
Mm-hmm.
Now, how does the lawyer supervise that? If the lawyer himself is not a tech expert, or does the lawyer have to be a tech expert?
No, I don't think they'd have to be a tech expert. I think they should be involved in the design process, in the you know, sort of making sure that things are being produced, that advice is coming out of the algorithm, and that it makes sense to a lawyer.
Like beta testing, the advice?
Yeah,
Okay.
and be sort of heavily involved with the team throughout the whole process. But I don't think a human can test all of the permutations necessary for one of these systems. That, I think, is actually where systematic testing is really going to shine in these systems, and actually might be a better system than we currently can test for human lawyers' competence. in some areas. I mean, we have a number of bar exam questions, and those don't test for every permutation of law, but it's totally a reasonable question to ask an algorithm to explain every possibility that every path that it could take through its algorithm.
So when you're talking about approving the algorithm, it's not just, my mind of algorithms like a mathematic formula, right? And so it's not just testing that the formula works, but it's actually testing the results of the formula and make sure that they're legally correct.
Yeah, it's like that legally the formula is based on sound reason, because you can build a machine learning model that there's actually some sort of funny correlation maps between like the price of cheese and the lunar cycle. And you can, if you torture data enough, you can get it to say what you want. So you can design an algorithm that links those two things.
Well, that's what concerns me.
Right, but and that's where the lawyer comes in. They would make sure that we're building something on a reasonable theoretical foundation.
Well, is it possible to have, well, let's say, the algorithm anticipates it has all the data for the correct law, but still come out with an incorrect answer when it's getting applied on behalf of it can?
Yeah, I would think so.
Absolutely.
Yeah.
So if the lawyer who's supervising it and everything that's going into the process is correct, but we still have the possibility of an incorrect answer, then how do we address that?
So I think this is very deep water, actually. What I would do is bifurcate this as a suggestion. I'm happy to dive into it. But the security portions of what Dan created primarily, maybe more straightforward to go through first. And then we could go through the sort of the more AI questions. Because that's, my short answer to your question, Judge Chang, is that you have to battle test everything. And you can audit, and you have humans testing it, you have courts testing it, you have a very strong certification period. Think of what they do for airplanes or drugs, right, to take Randy's example. It has to be empirically tested that it works to a very, very high degree of, you'll never get perfection, right, but you have to get something that's very, very good, and then when it fails, when there's an uncertainty level about a given situation, the algo doesn't try to do it. It kicks it out to a human expert. So what you do is you determine the cases that are more difficult, and you make sure that that isn't getting kicked out automatically. But my suggestion is to start with security maybe, and then go back to that. If that's
Yeah, the good thing about security is it's very well defined, and I have very strong opinions. So I'm just going to provide those opinions.
Just a question. So as we launch into the security discussion, I'm wondering with regard to the regulation of the provider of these algorithms, et cetera, is it intended to encompass both legal information and law-related and Scrivener-type services that are short of doesn't cross the line in terms of being something that might be characterized as the practice of law? So it's not providing legal advice or opinions or giving a legal conclusion or a recommendation. It's just giving information, which is what some of the providers in the field right now are doing. They are just giving legal information. They're not trying to be a substitute for a law firm or a lawyer. Or would the data security issues be different if you're trying to do all of that, if you're trying to approve a provider that could do everything?
So I think it would only be useful to a provider if they thought that they were going to maybe get close to that line, or they knew that they were going to go over that line. If they were going to build a product that really did provide legal advice, or got close enough that they were sort of uncomfortable with it. If they're very clearly doing a sort of a legal information service, I think this is more advisory. They should have good security and be ethical and all of that, but I don't think there's any, I think it would be overreach for the bar to sort of stretch its arms out into that existing area of the market?
I think that's such a good question that we shouldn't try to answer it per se. I would cover what's covered in the duty of confidentiality and flow from that, because that might you know, the practical answer, I think, as well, is that if you're getting information that is typically covered by the duty of confidentiality, it doesn't matter if you're the HVAC supplier that's hooking into the law firm's system. That may be an attack vector for a bad actor. So I think you're going to have to encompass, once you have that corpus, but I think we shouldn't try to answer that. We should just use the existing precedent.
Okay, so on security, I know there are a lot of acronyms in here. I'll briefly just sort of describe some of them. So PCI DSS is the standard that you have to meet if you use credit cards on a website. So this is most websites, because they all want your money. And it's a group put together. PCI is the payment card industry. It's a group put together by MasterCard and Visa and large payment providers. And they all said, okay, if you want to enter credit card information on your website and you want us to process it, you need to, for example, not use password as your password. Like that, I mean, that's really one of the pillars of PCI DSS. There are some other basic ones, like you need to patch your systems. You need to use antivirus software and anti-malware tools and intrusion detection. It's like a really basic level of security. And sadly, I don't think a lot of companies are meeting that right now, because we see a lot of data breaches that are based on default passwords. And you know, that's pretty painful to see, because they're just not, yeah, I can go off on a tangent for that for a while. Something that goes beyond PCI DSS is the Legal Cloud Computing Association, LCCA. They put together these standards a few years back, and they go beyond PCI DSS. They include things like backup and recovery, multi data center availability, so that if one data center gets hit by a meteor, you still can provide the service. Presumably, if you're providing a legal service, this is critical to someone, just as if you know, a lawyer was holding files for a client. Those files are critical to the client, and they have a duty to protect those files and have those files available to the client as the client needs. So I think there are some parallels here, you know, between the technology and the existing ethics rules. The LCCA standards, unfortunately, are not like super specific. They're more like guidelines, and there's no sort of broad certification body like there is for PCI DSS or ISO. It's sort of niche, and no one has sort of sprung up a consulting and auditing business based on these standards. I'm sure any InfoSec auditor would be willing to take your money to do it, but that sort of market doesn't exist today. So I think they're interesting. I don't know that I would recommend them. And then sort of the third level, the highest level of scrutiny is ISO. So the International Standards Organization puts together the 27,000 series of standards for information security. These are very expensive to comply with. My company, just to give you guys an idea, for the 27001 standard, we got a quote a few months ago for 15 grand to do the audit, the first round audit for ISO 27001. So they are quite pricey, and that forms a significant barrier that I don't know that we want to put in place. And there would be a lot of standards that would apply. 27001 would certainly be one of them. But yeah, probably at least 5 or 6 different standards.
Quick question. These take a long time too, right? It takes like a year or two to
Yeah.
get into compliance.
Hmm. Yeah. That said, they are very good standards. They're very, very well researched. They are extremely well put together and widely recognized, internationally recognized. And a lot of times they're actually written into law as well. You know, the standard is I guess the standards body has some delegated authority or something. So yeah. I personally would like to see something like the LCCA standards, but maybe with a little bit more definition. And I think it would be entirely reasonable to push them on that to sort of update those standards. I believe the head of that standards body is Jack Newton from Clio. We can definitely reach out to him and say, hey, look, we're thinking of, you know, depending on these standards, can we put some effort into updating them and being a little bit more specific about some of the vague areas. I think that would be a good way to go. Even though there's not a market to support that, I think having a good independent body that puts these standards together would be useful and would actually provide some guidance for other states as they go through this process as well.
Yeah, you might have the bar might take a position that accepts certain types of things as equivalent, but it might have its own recommendations as well, so it can kind of manage that. One thing to add here is that there may be a spectrum, right? So it may not be an option thing. You could have, you know, at a certain point, you can mandate at a revenue threshold or a size threshold, or if it's, depending on the importance of the legal procedure we're talking about, you may want to have enhanced standards under certain circumstances. So you can have a spectrum. So you might have an LCCA minimum threshold, and then you could have ISO for, you know, ISO is also a marketing tool. So if someone has ISO certification, it's a benefit to them, but you might want to reinforce that in certain cases too.
So I think we should talk about this before we move on to the next ethics rule. I think jumping off of what you just said. Okay, I wanted to talk about this security issue before we jump on to the next ethics rule. I think what you're saying is interesting about the spectrum. I don't think that revenue or size is a good way. I think it's more the nature of the services being provided. I think is probably the better way of doing it. But
so like if you're doing a giant M&A transaction, you need to meet some really high threshold. If you're doing a will, maybe you don't.
Right, assuming the will's not, you know, encompassing a whole bunch of really private financial type information. I think it depends.
Too,
right? Right.
Because the market might solve something in many situations, but it's a family law thing involving a death penalty situation.
Yeah.
You might have severity on that spectrum too.
Right. That's not a money issue. I think it's depending on the types of services. Okay, that makes sense. The ISO, as far as I know, I think that it is not a good idea to make the standards so high that becomes a barrier in and of itself. We don't do that for the lawyers, and that is, well, I'm not quite. You know, a lot of the law firms are doing it because clients are requiring it, but I think that, you know, whenever you talk about stuff like this, there's always the concern that we're going to push the little guys out. That's really not what we want to do, right?
Yeah, I can tell you my company wouldn't get a single one of the ISO 27000 series right now.
But, okay, so LCCA, why should we like them?
They're legal specific. They've thought about the legal industry and the constraints that a lot of legal software already has. So, you know, they've gone through and sort of prescribed some. They have opinions about some things like multi-data center strategies, multi-data center replication. I think they've taken a reasonable approach to a lot of the standards. You can go really, really far with information security and all these other aspects that they cover. You can say, this has to be, Amazon level availability, 99.99999% availability, and you've got to have, perfect zero data loss recovery strategy, and that all gets very expensive. But they've sort of said, okay, yeah, that. You don't have to have all that. Like, that's a little crazy. Let's take a step back and let's say something a little bit more reasonable. And I think they take a good approach to it for legal providers.
Who are they?
So
Who makes up the group?
it's mostly led by Clio, but there are other folks in the group. But it's all sort of practice management software. Yeah, so NIST does have various standards. There's NIST and FIPS.
Sorry, I was just asking about NIST. That's the National Technology Standards Group. It's federal government.
Yeah,
But yeah.
there are standards for some things. I would say a lot of them practically they're not used.
Too vague, or yeah.
Yeah, and they don't do sort of like the procedural kind of standards that ISO does.
Right.
Okay, so are we concerned that it's mostly Clio? That's one vendor, right?
Yeah, no, I think they're the ones that lead the group right now.
Okay.
I think it's sort of there's like maybe a half a dozen folks in it right now.
And they are representatives from different, like this, representatives from different vendors.
Yeah.
Okay.
Yeah, I mean, I tried to get Legal Robot to join like a couple years ago and got an email back from Jack Newton, and like it was very informal. I think if we push them to formalize some of their processes a little bit and add a little bit more detail to some of the rules, I think that would be an ideal set of standards.
So I had a question, Daniel. When we talk about security, what are our motivations? What do we want to keep in mind so that when we select these standards or modify them, what are the objectives that we want to meet?
I think primarily confidentiality. That's the thing that I think of most. I think there are other ethical standards. I have to look because I don't know these off the top of my head like some people.
There are a couple dimensions to that too, right? So there's the general kind of confidentiality preservation. There's also you think of bad actors, right? Hacking.
Mm-hmm.
There's also, just as important, the internal firewalling, right? So again, in an M&A example, what typically would happen without regulation is that a new provider will come in, they'll merge all of the secret M&A information from both parties, and they'll sell it to the highest bidder. Maybe it's another party, right? So how do you preserve and protect the information of each client from other clients? Because people are not designed to do that for the most part. They like to munge everything together. Lawyers get know-how, and we have a substantial relation rule, but that's actually a complicated engineering problem as well, how to firewall the individual client information and what's acceptable to use as quote-unquote metadata or analytics from that as know-how versus something that's truly protected.
Right, because don't the companies use the data for analytics?
They use it for everything.
To improve the product?
They can.
Well, they can use it to improve the product. The issue, so here's a nightmare scenario, right?
Okay.
You have a product that's being used, and I've tried to put the fear of God in people about this who are in this scenario, but you have a product that's being used by the court system, by both parties. And let's say you have a bad actor who's an employee at the vendor. Play says, oh, I can see what searches the clerks are doing. So it could be Westlaw, right? It could be anyone. I'm not saying this has ever happened, but what if they're bought off, or what if there's a security leak and that information is used to bet on the case? Well, it could be used to trade stock, or who knows, right? So there could be various scenarios where the information of the parties are not, or even the court system or other parts of the legal system are not being protected sufficiently from each other, right? So again, it's not just the outside actor we're worried about, it's also the internal data control system that we have to protect and engineer well.
Well, right, but if the companies are designing their product to use the information to help, it's kind of like the only thing I know is predictive coding, right?
Mhm.
The more you do it, the better it gets.
Correct.
Right? And so if every client who comes in and does it, it improves the product, you guys are not going to agree to allow. How do you,
That-
I mean,
that's
if we
right.
have a complete firewall, the product's not going to work.
It's not a firewall of the know-how of the system improving itself for that procedure. And in fact, let's say you had an M&A system that was a platform, right? Or a mediation system. But the transactional system you would want the software to improve with both parties' information, right? Specifically, as a client, might be better off. What you wouldn't want is for the other side to know, oh, I'm only going to accept 100 million or 2 million as opposed to, what they're offering. You wouldn't want specific intelligence about that transaction to go to the other party. What you were talking about, I think, is different, and you could define it differently because you're talking about analytics the system uses to improve itself. And so that, to me, is different. But there's a gray area, too. And I'll give you an example. So if Google uses my Gmail information, or any company uses, not to pick on any company, if any company uses my email information to do advertising, maybe that's okay, maybe it isn't. In some ways, for legal data, it's probably not okay. If they use it to send my information to a competitor from my email, or use it to compete with me somehow, that to me is a breach of whatever implied duty they might have. Even worse is if they take that and resell it. So there was a case involving Bloomberg recently. Bloomberg does trading information. It picks up trading information from all the banks. And the Bloomberg News people started using that proprietary trading information to make general comments about here's what banks are interested in. That created a blowback, right? So there are close calls, but in general, Judge Tang, I would define at one end of the spectrum is analytics the software is using to improve itself at a basic procedure. The other is stealing one client's information to benefit another or some third party.
Isn't it technically still a breach of confidentiality when the computer takes the information to improve the analytics?
Well, if a law firm is using a system to deliver a better outcome for the client, that's probably implied, but they have to make sure that that software isn't leaking that to a third party. So I don't think if it's an agent of the client, that should be okay, right? Even if there's some outside benefit to it. But if
if it goes into the big pot, it becomes an anonymous pot?
In theory.
Sometimes.
Can we force the anonymity of
the
that?
lawyer's
Yes,
answer,
but it gets
depends
really
is coming
complicated.
back.
So that where because you can anonymize data and it can be re-identified pretty easily these days.
So-
AI has become very, very good. They've reversed engineered from something called a deep neural network, which is this big statistical mess of stuff. They've dumped in a bunch of data. People have been able to reverse engineer social security numbers. So
medical records.
It's a very complicated question.
So you're getting me closer to, I don't think we can do this.
Right.
I don't think it's the right
so-
answer.
Yeah, and I actually, so I did address some of that. in
Okay.
here.
I think I'd like to add that when we started this talking about security, but really in addition to the standard things that we think about when we talk about security, it's data security, your hosting infrastructure, server security. In addition to those, as important is from coming to it from the aspect of privacy, so the user's information, and then confidentiality, and specifically, maybe this is something that's very specific to the legal field, is the internal confidentiality. Right. Because you rightly, Joshua pointed out that most systems are not designed to take that into account. So I think when we recommend something, we should make sure that we are paying attention to the internal confidentiality.
Yeah.
And Judge Chang, your comments about where you draw the line for a user's data to be used to improve the product. I mean, that's Dan is right. That's a very great.
Now that I've terrified everyone, though, there is some good news, and that's that every law firm does this already.
Yeah, I was going to say it's
Not
it's,
every law firm.
Well, every law firm that's
big law firm maybe.
every law firm that's fulfilling its duty has to firewall and segregate individual client data from other clients.
Yeah.
Well,
right?
right.
You can reuse. Here's the exact analog for what we're talking about. You can reuse the memo, but you can't reuse the advice and share it with another party, right? So before the associate rewrites the memo or the brief, they have to make sure it's scrubbed of the prior client's data. That's all we're really talking about, right? Is just automating what people are supposed to be doing now.
So,
and Heather, I think.
No, I was going to say, because
Oh, go ahead.
it seems that this is going to jump into the next section, which is talking about the integrity of the people that we're working with, and how do you start to put rules around that and the people that are being brought into this organization. Because it's just, I think about the data that's in our firm, and I see things in the press all the time, and we then go back and do a backtrack. Did that get leaked from us? From our clients, because one bad actor within the firm can do that. So how do you start to protect the data? And then we can start to put rules in place about who has access to the data, who has access to the actual names of the people.
Well, and a lot of this is interrelated.
Yeah.
So,
But I don't want to jump to the bad actor yet, because I think I want to finish talking about the vendor before we get to the actor, the user.
Right, because I'm seeing a lot of this already happening in technology. So we have Lex Machina right now, which is pulling a lot of this information together and giving us analytics on whether or not, how judges react, to cases. So we don't actually have the information from the specific cases, but we do know that, this judge with these circumstances is more likely going to do A or B. So that data is being culled and being, pushed back out to people right now. So we are seeing it. We're just talking about doing it for a different market.
yeah, so a lot of this does relate back to those standards. So the LCCA standards, for example, do mandate that you can track down, who's accessed a particular record. So they mandate a particular type of audit trail. So that there are a lot of concerns that are controlled for in some of these standards, and that's why I say the LCCA standards go further and are a little bit more tailored towards legal use cases. I think there's a lot of relation between these different sections, specifically related to confidentiality. I think they cover that quite well, but there are concerns that I addressed in here that are both from a security perspective, as well as from sort of confidentiality with respect to data processing, and that's I think where a lot of your concerns come in. Very, very valid concerns, and I share a lot of those. And the way I wrote the confidentiality and data processing section was extremely conservative, because that's how I, as a consumer, would want to be treated. It's just my opinion. We can work on that. But what I say in there is, encryption is a suitable firewall, and as a consumer, I don't want any of my data being used by any other customer. Any of my identifiable data being used by any other customer.
And so there's a couple things we can do, right, that are good. Because I think in some ways we're already doing that. The law firms are supposed to be doing firewalling data as it is. They're not always good at it, right? I think that's legitimate. There's simple things we can do. Simple certifications rules that should improve the situation and the function. There's also standards. They're not going to replace having standards, having audits and ombuds, women and men, looking at things. But I think you need both, right, to get to a good enforcement and security picture.
Well, I guess I'm less thinking about the firms. I'm
Right.
thinking about the solo practitioners who don't know how to turn their computer on. I'm
Yes.
thinking about the direct-to-consumers, the
Yes.
consumers who are looking at this and they
Yep.
don't know. That's what I'm really focusing on right now, just
Yeah.
because I think that's kind of, the access to justice issue is really for that group of people. And they're not, I want to make sure that what we're authorizing will protect them from misuse.
Yeah.
By the vendors. I'm not talking about other people. I'm talking about the
Exactly.
vendors themselves.
So consumers have to know exactly what they're getting. So they're not going to know what ISO is. No one's going to know that, right?
And I don't
Most
think we
lawyers
should
don't.
expect anyone to.
No.
But we should say this, if you, so if you look at the Fair Credit Reporting, again, I'm not endorsing any partisan bill or anything like that, but if you look at what happened within the credit card industry, and they started making people label and do the marketing and communications as to, here's what you'll pay if you pay the minimum, here's what you'll pay if the thing. That kind of simplicity forcing function, I think, is necessary here. So it's like, if you want to really protect it, there's risk to putting your data in the system. Here are the risks. The risk is less if they have ISO or if they have this extra seal of approval from some authorized commercial vendor, right? So I think we have to think about the full spectrum of this, including in particular the consumer, what you have to disclose to consumers or not.
So we're thinking of addressing it as a pure disclosure issue
No.
and not as a standards issue on the vendor.
No, I think we have a standards issue. I think we have a disclosure protocol, and I think we have also standards and cross-checks.
Okay.
So there are a couple different sort of harms that I was thinking of in this. So as a consumer, for example, or a small entity, you can think of a couple things. You don't want your data to get out. Just don't want it to be leaked. That's sort of the security, thrust. There's the other sort of side of that is you don't want to be unfairly tracked and monitored and have your data resold and all of that. And I see that as the sort of data processor's responsibility when you're working with this data. So I separated them out into two sections. It is possible, and this is where, again, I'm totally putting this out as opinion. It is possible to perform machine learning on encrypted data. We do it. It's possible today. It's a little harder. It's not that much harder. We have what's called a fully end-to-end encrypted system, meaning my team can never read, and I'm sorry, I don't mean this to sound like a commercial, but anyway, this is the way we've designed our system specifically. We can never read sensitive client data. We've designed our system in a way that's using principles called privacy by design, which I reference in here. And that means that only that customer can ever access their data. If we get a subpoena, we can turn over the encrypted data, but we don't have the key. So good luck decrypting it. And that's sort of been our strategy behind a lot of that. On the device, that information gets decrypted, and then you can perform machine learning on here. Most models, not the really, really new ones that came out like in the last 2 weeks, but most models will run on a device this size. So it is totally feasible to perform the most advanced operations on a small device. And it does take a little bit of extra work, but I think that work is an option for these companies. And the way that I frame this is, well, you can go and do a client conflict check on every single person that uses your system. And you can make sure that that you're not conflicted on anyone, just mirroring the lawyer's rules, right? Or, which totally isn't feasible for a SaaS business. Yeah. Or you can use privacy by design principles, and you can, by design, protect and wall off sensitive information from use by anyone else. That doesn't mean that you, as a company, can't learn from that information.
Right.
you have to use techniques. There are techniques called like differential privacy and homomorphic encryption, which allow you to still perform all the necessary analytics on that. Again, it's just a little bit harder. Well, homomorphic encryption is a lot harder, but differential privacy is a little bit harder. They're using it for the next census for all the statistics. It is doable. It's possible today. So this isn't, we're not asking like a whole lot from companies to do this stuff. We're asking them to be not on the cutting edge, but like up to date, you know?
The other thing, and again, we can look into the current regimen right now under duty of confidentiality and related doctrines. Training and agreements are really important. So Heather brought up an example before. My hypothetical example was not hypothetical, of course. I literally had a conversation with our people to try to put the fear of God. Like, you will end up in federal penitentiary if you take data and mention it to your friends. You know, I mean, this is a real conversation. So we have to require that people have some kind of training and legal agreement, confidentiality. I think it's just common sense, but we can make that part of the specific regimen as well, just like the technical cert.
For the employer, for the vendors.
For the vendor, yeah.
Yeah, yeah, I
Does
think
it work?
that's.
Does it work for them to just agree to be bound by the certain of the rules of the ethics rules, or do they need their own rules?
I think, honestly, I think we can replicate all of the ethics rules. They get interpreted a little differently,
So we
and
can-
some of them don't apply.
So part
But
of the certification process can simply be you agree to be bound by the rule 1.6 rule, and we select the ones that are applicable, and then we don't have to write more rules.
I think so.
Yeah, conflicts is going to be the really complex one, right?
I'd say keep it.
What's that?
I'd say keep it, and that's the motivation to push people into privacy by design.
Right, but no, we keep the sentiment, but what you're saying is that the vendor couldn't take, you say there's one really good technology vendor, right? Hopefully there's not. Hopefully there's lots of them. Say there's one really good one, okay? And then you say one part, for whoever gets that first, the other party can't use it.
Right.
So that's an access to justice problem as well.
Well,
Again,
under our prospective client rules, I don't even have to actually hire you. I just gotta drop that information at you, and I'm done.
right.
Right? We
Right,
can do that.
you've now denied access to justice to someone because we've applied very strictly the conflicts rules. So again, I would break that question off and ask for Randy and Brady's
I
help.
actually just like to require this encryption standard, period.
Yeah.
And to put the conflicts rule on top of that, but if you're applying with this, the conflicts rule is not gonna apply.
Right.
And remember, all of this is voluntary. Like, we're not saying, every legal tech vendor must do this tomorrow. We're saying, look, if you want to encroach on this space, if you want to expand your market into something that looks a lot like legal services, if you're really kind of wanting to cross that line into providing legal advice, okay, here's what you have to do.
Well, I'm already hearing advertising for products out there, and just, that, you don't need to hire a lawyer. You can utilize this product. You don't need a lawyer. Get legal advice without a lawyer. So I haven't written it down yet. No, but I'm saying, but I haven't written.
Prosecution workflow is being generated.
No, but
right now.
I didn't write it down, but it was one of those things just over the weekend where I heard it on, some CNN, somebody was running some advertisement on it. And, I wish I could have rewound my television to get the company that was doing it, but.
Incorporated in the Seychelles or something.
Right, but, when I'm sitting here and I'm typing my notes for, our further discussion, but those are the types of things, like making them required to, to adhere to the same advertising rules that, the law firms have to, and the ways that we can do that and push that through. I'm looking up
The system
here.
has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response, the conference
It's
will
like,
end.
what? But I think that, there are things out there, like as we were saying, the legal standards are out there, but we also have, the new, the California Consumer Privacy Act and how that comes into play, because as I'm reading it, there's certain dollar amounts, minimal dollar amounts for the companies that they have to adhere to before they're required to abide by these new regulations, but we can push that into a company saying, we don't care if you're at $25 million. If you are going to be certified we
Yeah.
want you to adhere to this.
Yeah.
So, I think it goes down to being able to create, what the bar feels is important standards to be met to protect the citizens of California.
Yeah,
Well,
I think we can look to third-party associations, but not rely on them per se, right? So we can say, if the legal association's one qualifies, say this qualifies, but there may be others, right? And
Right, so the ultimate authority of deciding what that is resides with the bar.
yes.
Yeah.
Sorry, because I know you're not at all of the meetings, but I'm just wondering, what is the rationale for the voluntary nature of this whole paradigm?
Antitrust. I mean, in a word, so if the bar all of a sudden goes out and says, all legal tech vendors, you're under my scope, that I think would be concerning to probably federal authorities, saying you're probably overstepping your bounds.
Yeah, I would take a different view. Go ahead.
Well, I was just going to maybe help clarify that the voluntary nature is, it's not voluntary in that you only get this safe harbor from UPL law if you do this.
Yeah.
But if we're worried about, if the goal is to protect the public, I mean, I feel like there must be ways to address the potential antitrust concerns. There are other entities or places or jurisdictions where there is universal regulation of a certain business type. So I just wonder why.
I think this is the easy way around that for right now.
And I think it partly historically with us sprung from the difficulty of defining what's the practice of law. I mean, there's a statute, but it's vague, and it's sort of a when you see it thing that comes up in a court or when there's actually prosecutions. So the thought is, hey, if you're crossing into that gray area where, historically, I guess, providers have avoided providing certain services because it looks like it would be UPL, here's a way you can do that without getting prosecuted.
Yeah, let me try to clarify. I think it's mandatory if you want to fall within certain procedures, right, that are close to the practice of law. And again, the concept is, it's just theory right now, right? The theory is it is mandatory if you want to do this function. I think as the state, California is empowered to obviously regulate appropriately within the Dormant Commerce Clause, but the main thing is it's mandatory if you want to do this certain thing. Is that fair?
Right.
But the issue, I think, the concern that this raises for me is we do have entities now skirting right on the edge and perhaps authorizing unlawfully. They may not be inclined to want to get our seal of approval, not feel like they need to incur those costs. And we don't currently have a structure which allows us to regulate or address that behavior, other than the individual lawyer who may be choosing to provide services through that vehicle. It's an inadequate response that we have available to us now. So that's my concern, that you'll still have those groups floating out there.
I think you put it in the bill, yeah.
Well, I mean, those entities are subject to current law, right, which is the DA. It's a criminal prosecution. The issue of the DA not really doing that is, I think, I'm not sure that's something we can take on.
But
That's a big issue, right?
And right now, like, our UPL work is very focused on the individual attorney.
Right.
We don't make referrals to DA's offices for firms. Where we make referrals for individual attorneys. So I don't know who, even now, I don't know who is sending the DA these cases, how they're finding out about it. I just feel it's an area that's sort of the Wild West.
What about the notarios who don't have a lawyer involved?
Right, they're individuals that we make the referrals on, not the firms.
Not the entities.
Yeah.
But wouldn't the overall idea being that we can't regulate everybody, but if people or these companies come to the bar and get certified, they get a little badge that goes on their products so that when the consumer is out there, and obviously it becomes how do you educate the consumers to look for this, but that the consumers can, then see that this product has been certified by the state bar so that they have comfort in knowing that, this company has met these standards, that they're taking care of this, that this is a valid company out there, as opposed to all the other ones are out there doing God knows what.
Yeah, I mean, there's definitely a little marketing uplift there, but as a business owner, the thing that I always tell my investors is the thing that keeps me up at night is some state bar coming down on us for UPL.
Right.
That is the one biggest risk to our business, in my opinion. So if I can eliminate that, that's a much bigger driver for me than like a marketing thing.
I mean, I think that's maybe another subcommittee, because the regulation and the statutory authority, and maybe it's not our subcommittee, right? That's a much bigger issue. But as we think of, depending on what modus operandi the bar decides to take with whatever recommendations we end up with, whether it's to not change anything or to change things, my suggestion is that be part of that, aircraft carrier.
Well, I would think that once the subcommittees each explore what their vision is for their aspect of what the regulated entity might be, then we get back into plenary session, the very broad stroke level discussion of, well, now we've got, the seeds of an entity. Is this a mandatory policy? Is it a voluntary policy? Is it a pure lawyer disciplinary remedy policy, or is it some new enforcement vehicle policy that we're going to? I think those are things that we want the minds of all of the task force members to chime in on. And so I think you can put it on the side until we get there.
We can put a pin on it. Here's my 2 cents. I think in terms of what is happening in the market right now in the world, I think it's a mess. I think there are all kinds of professions that are not just encroaching, but they're carrying out full-on legal functions. And lawyers are not in a position where they can necessarily handle that work all the time, which is why automation, in some part, well-regulated automation is a good idea. But I think it's a mess right now, and I think it as an ancillary to this conversation, and it's part of the give and take that there may be, we're going to grant this certain right, but we're going to have the right to enforce. I think that should be part of the same conversation.
I mean, it's really interesting to hear, because I think it sounds a bit like some of the conversations we've been having in a different working group that Greg's been participating in, which is whether or not, addressing this question of whether or not malpractice insurance should be mandatory for attorneys. I think Judge Chang, you were sort of referencing that, and it's not. And so one of the areas of discussion has been how effective are disclosure rules, kind of this notion that if you educate the consumer about what they are or aren't getting with various products, they will make an informed choice and it'll be the right choice. But we see on the malpractice insurance side, certainly that is not a very effective strategy, and your consumers are not that well educated, right? And the group that we would be really targeting with the access to legal services focused technologies is really not have that level of sophistication, I don't think, to understand the impact of different security standards. Yeah. So that doesn't seem to me sort of an effective way to address the public protection concerns. However, if what you're saying is accurate, that the companies themselves will be so motivated to pursue this because of the risk of being shut down, or there is some business risk that is so significant that will drive this voluntary compliance, then maybe we don't have to worry about whether the consumer is the appropriate entity to make the right choice.
I think if this moves forward, part of the sort of program launch of this whole effort needs to be a really, really strict enforcement mechanism right out of the gate. You saw when GDPR first hit, everyone was sort of looking around like, okay, who's going to be the first one? Who's going to be the first one? And to date, there's been a few prosecutions, but it's not been that there's some fines, but it's not been what everyone feared. And I, as someone that might be the recipient of a lot of this, I don't want to promote this too much, but I think that fear is a really useful driver to push people towards this optional program, this voluntary program, and have them improve their practices and protect the public. And I think that the only driver for that is going to be fear.
So just to take off from that, Daniel, was it, how would you see the enforcement process?
So that's the great thing is I think the enforcement is already there. I think the statutes are there. I think the mechanism is there. Maybe the staff isn't there. You know, I don't know how overworked the bar staff is, but I assume it's like every other state agency and
Use AI
fun
for the
times.
enforcement.
Yeah.
Right, but there's a way, is there, I mean, I would
Should.
like to ask the OCPC office if there's a way to estimate the cost of a prosecution, and that way that can get folded in to the
Yeah.
actual fee paid by the company wanting to do this, so
Right.
then that cures the staffing issue.
Right.
So you're anticipating a full, just, you're gonna pull the entire discipline system on top of this in all its glory? Is that what you're thinking?
I don't see why not.
I also think that if you have an ombudsman type requirement, whether it's a full-time or a part-time person who's either they're part of the state or they're they're an attorney, she can pull a certification, right? And so that the threat of the loss of certification may be an incentive as well. So
But
that's short of
isn't-
a criminal prosecution, right?
No, but that would be the end, it's the equivalent of disbarment, right?
Yeah. Right.
In the discipline system.
Right.
So that's not one person,
And
that's just.
well, no, sorry, that's not just one person, but again, you might have to.
I think you're
It's
gonna
a-
have a
it's
lot
a-
of due process concerns
You
if you just list one
do.
person who gets to
Yeah.
go, nope.
Well, yes, unless they're also an agent of the party. So I'm not recommending anything per se. I just think we may not, we can't necessarily rely on just criminal prosecution. The analog that I would look at is the securities world. Again, not recommending that it may not be appropriate for many places, but they have all kinds of, the NASD, they have private associations, and they have
FINRA.
Certification. Sorry, yeah, FINRA.
Right.
So it's a mixture. They have private bodies that are funded by the industry that also help regulate.
Well, I
They-
think.
They don't replace DOJ, they don't replace the SEC, but they're a supplement to it.
Right, but I think having multiple regulatory agencies is gonna be an issue, right?
Yeah.
I think he's not talking about criminal prosecution, it's the administrative prosecution through the Office of Chief Trial Counsel.
Right.
There's also always the ancillary possibility of a district attorney prosecution as well.
Right.
But I don't think they normally do that if the bar is acting. I don't think they do, right?
Right.
Well, and that's one big hole in this proposal is, you know, through sort of prosecutorial discretion, the bar could say, you know what, you've got this safe harbor, you've met all these requirements, we're not going to prosecute you. And I think that's possible under the, you know, the rules that you guys operate under today, but that doesn't bind a, you know, a county DA or whatever, you know, whatever local DA by the same safe harbor. And that's kind of a problem.
I would also compare it a little more to like a driver's license, right? Which is not there's no right to it, and it can be taken away. There's a very specific procedural protocol that has to be followed before a driver's license is removed, but it's not like, you know, removing someone's constitutional right.
Yeah.
Yeah, I was just gonna say, we'd be careful about just saying, let's replicate the attorney discipline system, because it's really a behemoth. I think you'd want something a bit more nimble, that
So-
of course afforded due process, but I think that could be thought through. I just wanted to add in terms of the cost, I think that's way down the road, but the approval process that's contemplated with these interviews and sort of like the moral character informal conference, that will be a very expensive, I think, staff resource intensive type of approval process. So to the extent that matters, it's just something to consider. Not saying that it's not the right approach, but it's certainly very involved. Yeah.
I think that would largely be not CalBAR staff. I think that would be independent reviewers that are maybe certified or something by the bar or you know, come and sit in the bar office.
Almost like attorney mediators.
Yeah, sort of like, you know, call me in for a few days a year and have me help review an e-discovery vendor, you know, so it's not conflicted, and call in, you know, a law professor and, you know, some other expert, and the three people form a panel, and you sort of go through. I think you can source a lot of this publicly rather than hiring specific staff, because I don't know, I mean, I'm not sure how many companies are going to go through this.
I see. So they might not necessarily self-fund from the get-go. It might take a while.
It might take a while, but I think enforcement can be part of that.
But you had an idea, which I think is, I think we should look at really seriously as a means, is how to do the workflow and at least automate part of the workflow of the regulation system.
Right.
It doesn't have to be strong theory AI that's saying, you know, removing something, but it might be detecting an issue.
Right. Monitoring, detecting, and
the process should be
right.
Yeah.
So what program are we talking about? Something that gets put on the State Bar's computer system? I'm not sure how we do that.
It's something that is, I think there are ways for every workflow, even getting our documents right for these events, there's things we can do to make sure that it's easy and fast, right? So streamlining the
Let me introduce you to the
process.
California Department of Technology.
Again, I'm not saying it's all done internally.
We don't have to go through them.
Yeah.
We do have the ability to be a little bit more
good. Okay.
flexible. But I think, I think it's interesting. I'm not sure there will be so few companies. I guess if it's voluntary,
I mean,
I've
in the
been thinking this could
100-ish.
take over sort of in magnitude the regular work of the State Bar.
Yeah.
I see it being quite large, actually.
I don't know. I would guess in the sort of initial wave, it would be in the hundreds of companies.
Oh, you think that's not a lot?
Well, I mean, I don't know. I mean, I think, you talk about like a half-day interview with each company, maybe a day on top of that of document review time. I don't know. Doesn't seem so bad, right? Maybe I'm just an optimist.
Again, I think from a process perspective, if we think about what result we want at the end of the day, like what outcome, what ecosystem we want, and then we can reverse engineer maybe the most efficient regulatory regime for it too.
But actually, just before you go, I think it would be really good to like get more input of like how you guys would design this whole system ideally for your process. Yeah.
Good. Thank you.
Thank you.
Thank you.
Yeah. Should we take a short break?
Yeah. Let's take a short break and get something to eat.
One point of order, helpful to me selfishly. We didn't assign a scribe earlier, so if anybody wants to volunteer, I'm taking notes, but to help provide a backstop for our. Okay, so we can. I'll chat with you afterwards to get it. Okay, Dan will help out. Thank you.
Thank you. Let's take, let's get food and come back here, maybe, continue.
Around
Yep.
1 o'clock?
Let's start in 20 minutes. Is that okay? Sounds good? Yeah.
Yeah.
All right, so let's get started on after the break here. So we have about an hour, and we have several items on the agenda to cover. So we'll keep moving quickly. First, we'll have Judge Wendy Chang give a quick presentation on the enforcement and the different approaches to enforcement.
So I think we already started that discussion before we went into the break, so there's no need to get too into it other than to talk about the memo I think I wrote that analyzed the current disciplinary system and the several levels that are involved in it. And then I thought there were three potential alternatives, which is to adopt the system as a whole, adopt kind of make it a little bit more nimble, like Leah was saying, more nimble, have fewer steps in it to make it work, or do nothing at all and it just go with the current law, which is when the state bar sees a company, they refer it over for prosecution. I think.
Welcome to Reservationless Plus conferencing. Enter your conference code, followed by the pound or hash sign.
So I think the issue with the current law is that it's not really being enforced. And so you'll hear every once in a while that the state bar with the DA will go in and close down some business.
Thank you.
But
You are
I
the
don't think
first
they do that
participant.
much. And there was a time I heard that the state bar was going to set up a civil arm where they were going to go after these non-lawyer based companies under 17200. But I haven't really heard of that actually happening. And so I don't believe that the current law is a really effective model for it. I do think that the current disciplinary system, there are so many steps in it, might be too much. So the thought, from my perspective, is to create a simplified system. But there's a precatory question. I mean, and I think we answered it already, but I wanted to raise again, and maybe it's worth a plenary discussion, is that the current bar regulatory system only applies to lawyers. They don't go after companies, and they don't go after firms. And so when we're talking about these registered companies, we're not registering people, we're registering companies. And so there's a little bit of a disconnect that when the disciplinary system comes into play, we're going to go after the lawyer who's certifying, but when the registration itself went into the name of the company. So I'm not quite sure how that works. And I also think that registering, but saying that you were going to discipline a company may raise a lot of issues, because I know there's a lot of controversy over the state bar assuming jurisdiction over law firms. And so I just think that's worth a discussion at some point. So that's it. There's not much to talk about other than whether we're going to recommend one of the three or maybe even something else. Maybe, I think the other alternative I thought of a possibility of was just a private system that the state bar would accept. But to me, there's a lot of downsides to that.
Wendy, could you talk a little bit more about your recommendation, though?
My recommendation would be, I think the state bar should keep control of it, because I think if the state bar doesn't, it loses the certainty.
Wendy.
Huh?
Should keep control or take control? And by keep control, take control
over whatever disciplinary system that we end up recommending. It'll be the kitty corner to the registration aspect of it's the other half, that what you do, there's some kind of a violation. I do think having too many steps in it opens the door to gamesmanship, and it creates too much, I think, work for the state bar to analyze the different levels of compliance and non-compliance in this very highly technical field. I do think it shouldn't be a one-shot, okay, you violated, you're gone. I mean, there should be some analysis of the degree of the violation, but I don't think there should be too much, because I think it'll make it too hard. So my recommendation is to adopt the system, but to make it a little bit more simple.
Thank you. Any further comments on that topic?
I have a question. I'm looking for the code section right now, but I'm not seeing it right. There is a mechanism for the state bar to seek an order from a superior court to take over a firm that is engaging in UPL for the protection of the clients. What about having some sort of code section that would do something, allow the state bar to do the same with a legal technology provider that is engaging in UPL, hasn't gone through the certification process? That would expand their jurisdiction. That would require legislation, obviously. But
I think it's a great idea. I mean, from a public protection perspective, I think those kinds of companies create so much havoc and create so much harm that it's a good idea. Because I think once you put the certification out there, it's going to create this, I think, this new market. And there are going to be a lot of the good vendors, and there are going to be a lot of the copycat vendors who aren't that good. And I think the danger, there's going to be a concomitant danger, I think, with this.
I would second that, and it's to the take comment as well, that if we're giving something and giving an authorization and certification in their statute, that the bar gain the ability to regulate a lot of that shadow traffic as well. I hate to use too many techie examples, but it's maybe relevant. If you think of Napster and online file sharing, it was chaos and bedlam, and then there was the big Napster case that came down. And then you have all of a sudden in the shadow, after that those set of cases came in on file sharing, all of a sudden you had Apple iTunes, and you had real commerce, and you had commerce in movies and television as well in a way that was healthy. So if you create the regulatory system that's going to kind of reasonably govern this, by extension, I think the bar should take more regulatory authority over the shadow of that.
The reason I raise it also is because I know exactly, Judge Cheng, the legislation that you were referring to that would have allowed the state bar to seek civil remedies in UPL cases, which it can't do right now. It really doesn't have standing to do that. That died.
What is the scope of the statute that?
Yeah, I'm trying to find it right now, but essentially, I'm going to paraphrase it, and then I'm going to find it and correct myself later. But if the state bar receives a complaint, and this is really focused in the last few years on these notarios who are setting up shop and providing immigration legal advice to vulnerable client populations. So that has been the focus. I think that's probably was the impetus behind the legislation. The state bar can go into Superior Court and seek an injunction, basically an order from the court that allows them to go in and take over that firm's files and take reasonable actions to protect the clients.
And so that's really beyond regulation of lawyers. Yeah.
That is beyond the regulation of lawyers, but they have to obtain the order from the court. They can't unilaterally do that.
I mean, you don't want the state in the position of running a bunch of legal tech companies that it has to take over. But
No.
if it's a managed shutdown process, I think that's totally appropriate.
And I think that would be, Brady, do you know how often the state bar has done that?
So I don't have the exact numbers on how often, but what we do, we don't take it over. I mean, we do technically, right? It's an assumption of the practice, but we take all the files, we freeze the client trust accounts, and then with the files, we reach out to all the clients to get them files back. They're active files. So if they're active, they can find other attorneys. We may try and find another attorney to take over sort of all of the files, but mostly it really is about distributing the money that's in the trust account, returning the files to the client. We aren't taking over in the sense of actually sort of performing the practice.
And as part of the process, go ahead. Yeah.
So in terms of, there are those kinds of processes, and we have very extensive processes in place for having the phone lines transfer here. So if somebody calls that office, it's transferred and those calls get answered. So we do have processes like that,
So no, we wouldn't want to sort of take over the operation of a tech company, but we do have the ability to close down the practice and to sort of get the information and sort of do what we need to do to make sure that the clients
Right. The focus is protecting the
whole.
clients.
Yeah. We
And
wanna
how
keep it
often
whole.
does the state bar actually find counsel for those clients and transfer them to?
I think typically we don't. Typically we get them their file so they can get counsel. I can
their own
get somebody from OCTC down to tell us a little bit more about it if you'd like.
Mm-hmm.
How is it different than, I know it's why is that, isn't that like a special master procedure or like the technical committee or doesn't the court have the authority to do that anyway?
The court would have the authority to do that, but it would allow the state bar to be the one that actually files the petition.
Automatically be actually filing it. Okay.
So it gives us state bar the authority
It gives them
to be the petitioner in that circumstance and
I
proceeding
mean,
to
in a
follow.
technology context, would that be, give us your AWS access keys and, we'll, get into your database and start contacting people and sort of start shutting down the service in a controlled way? Because that's going to take a lot.
I don't know practically how that would,
that would take a
work
lot
and
of
what would be
technical
required to protect those clients too.
Yeah.
I mean, when you're talking about some of these, unscrupulous, unlicensed lawyers out there, they may have a couple hundred clients. I can imagine if,
You could have a million.
You could have a million clients. So, and I'm not saying the court endorses this idea. This is only my idea of a company. It just occurred to me. It just occurred to me that mechanism was there, and that is a problem. It's a perennial problem actually, because the other thing the state bar can do is refer the matter to either a local DA's office or to the Attorney General's office for prosecution. But as Judge Shang is alluding to, they're just not prosecuted because they're not high priority for a lot of these prosecutors. So this allows the state bar to at least do something to protect those clients, and I'm not sure how that if you were to pursue something like this, whether or not as a proposal, how exactly the state bar, what the order would look like, and what would be expected of the state bar.
I mean, I guess it would be similar to what would happen if that company entered bankruptcy.
Mm-hmm. And I'll tell you, that legislation that was referred to earlier, where the state bar would have been able to go and seek civil remedies. I mean, part of the concern, and this is the court's concern, obviously, is the state bar has a certain bandwidth already, and their main function really is admission and discipline of attorneys and protecting the public in that way. So this could potentially be a difficult thing for them to administer under their current financial structure. But this is a problem, because I think you have to have that enforcement mechanism there as well.
I think as Leah alluded to, I mean, it's a good thing for the bar itself to be, it's a good thing for the bar itself to be generating their own, wisdom on and coming up with some realistic ideas. The other thing, though, I would say is it may be possible through the alternative business methods or whatever that's ended up being called, that there may be new mechanisms for funding as appropriate. Again, not to create fiefdoms or anything, but as appropriate, you'd have to create the funding mechanisms. And you'd be able to get vendors, right? So you may not want a situation where everything has to be done by the state. The state may be able to pick and choose things and get help, as well as having the financial wherewithal to be able to handle the new burden.
I had a question. So when you think of individuals, typically operate within the state, but if we have a company that's providing a solution, these are more likely to be operating across the country or even internationally. So how would any enforcement mechanism apply just to operations in the state versus?
Well, I mean, all you have to do is look at how they did it with LegalZoom, right? It would
How
go
did they
state
do-
by state.
It would go
And,
state by state.
but my thought is, if we come up with a very viable model, the other states will look at it. So it may not be a situation where it ultimately is only California. But just closing off California market to a company, if that's all we can do, I think that's a real significant thing for a company because it's such a big market.
It's what, one in 8 Americans?
Is it 1 in 8?
I think it's either 1 in 8 or 1 in 12, I forget which. It's a bigger economy than. Yeah, it's big.
I have a question though. So if we're only regulating and disciplining, so have you guys come to a consensus as to whether you feel the state bar should be regulating and disciplining companies or attorneys? Because if it's companies, then what keeps them from just dissolving and creating a new one tomorrow?
It's a good question.
Whereas right now we are regulating attorneys, and if you get disbarred, you can't go off and be a lawyer somewhere else in California. It just doesn't work that way. Because, you have to be licensed with the bar. But with the company, what keeps them from dissolving, just picking somebody else to be the talking head and creating a new company and doing it all over again?
So I think in
That's
the
the
certification process, that's when you kind of try to pick
So
that up.
certification of a company or a
Right, so
person.
you decertify a company, they try to reinvent themselves with a new
Mhm.
Hydra head, so to speak. Not to use this loaded metaphor, but they come back again and you're like, you're all the same people, right? Or you try to they really are different.
But
That's hard to catch,
That's
right?
if people are actually going through the process.
Right, but if they come back around, you're saying that if they're never going into the process in the
Yeah,
first
I mean,
place.
if it's $800 a pop to form an LLC, I mean, you just keep on forming them with new directors. You could ban the directors, and that would mitigate it to some degree. But
you need a.
No, but what I'm saying is you can recreate a company, right? Okay, let's say I'm the bad actor and I had a company and then I get decertified. Then I go say, hey, you know what? I'll give you my technology. You start a new company. You hire me as a contractor on the side, not on your board or anything like that. You give me a sizable amount of money, and this guy's back in business again.
Again, I think you'd want a mechanism to, if not investigate, at least diligence the people that are being certified again. Again, I'm presuming there's some benefit to certification, that there's a disadvantage to not being certified and practicing law, right, technology-wise. But I think that you'd want to be able to pick that sort of thing up in the diligence process on certification.
So if you're looking at the product and it's offering the same services and you're recognizing the algorithms, stuff of that nature.
The humans are going to be able to pick that up, right? And they're going to say, this is this thing that was banned for this reason, right? I'm not saying it's
Well,
easy,
if they've
but-
got that good of investigatory, because if the person's a subcontractor, the person's never going to show up on anything. All you're going to be able to do is recognize the technology, right? So how are you going to be able to prove that it's the same company or it's the same technology?
They can always get a new UI, user interface. They can hide it in a lot of ways.
Yeah.
And eventually, there's some of the products are going to be so similar anyways. Once one company comes up with something and, like you said, there's all these copycats, per se. A lot of them are going to look the same.
Is there a kill switch we can retire?
We'll just shut down the internet.
No, it's a serious question. Is there a kill switch possible?
practically no.
Oh, sorry.
Can I?
No.
Oh, go ahead.
So that the provision was, yeah, I did. Business and Professions Code 6126.3. And yeah, so the petition would require, the court would assume jurisdiction over the practice. The state bar could bring the petition, or the Superior Court could do so on its own motion. And then the court may appoint a member, or I guess a licensee of the state bar, to do any number of things, including taking possession of the client files, examining them, getting those client files to the affected clients, and also arrange for the appointment of a receiver, where applicable, to take possession and control of any bank accounts relating to the affected person's practice.
And so I think the process of appointing somebody happens, and I've emailed OCTC to see if they can come down, but happens more often. So there are issues with like the death of an attorney. There are issues with unauthorized practices of law, and we shut those down sort of at the same process. So the 6126.3 is the UPL case. And so like if there's a death, like we might be able to know that you know, there's a partner that the lawyer had been working with, and they're willing to take the cases. So I think that happens less often with the assumptions that we do, and hopefully somebody from OCTC will come down and tell us that, but I think more often than not, it's us just returning the files.
So I think, you know, just going back to Mimi's point of, you know, the bad actors that are out there, there are already bad actors out there. There are always going to be bad actors out there. However, there are good people out there who are acting and are trying to do good things. And I think that's where the concentration really needs to be at. There are people who are trying to get good legal services out to people out there and having a process that they can go through so that they can distinguish themselves from the bad actors then allows, you know, whether it's the courts or for the state bar, to be able to easily identify who the bad actors are and shut them down.
And as an adjunct to that, I just add one possibility is you create a disclosure obligation when someone's trying to certify, and you've got to tell them you got your tech from somebody else. Who are they? What's their name? And if you fail to disclose, maybe there's a potential criminal liability or something like that.
I have a question for the two of you. Is there a possibility to seize the technology?
I'm sorry, to what?
If you have a business and professions code that allows the court to go in there and take control over a UPL legal tech, I think seizing the money is great because that's going to really, really make it difficult. But seizing the technology, can you do that? To seize the IP.
Once you seize it, what are you going to do with it? We're going to need the expertise, right, to seize.
Well, you could have like a technology receiver, receivership for the technology. I mean, that could be a thriving little business. You essentially bid on the technology, on the seized technology.
What would that achieve, though?
But once you have the money and once you have the technology, isn't it harder for them to just put a new face on themselves and be somebody else?
Well, there's a couple.
It's not impossible, I know, but it makes it harder, doesn't it?
It depends on how the technology is built. If it's completely proprietary, maybe, but the way all of this works is that the frameworks that people use, libraries that people use, and you cannot really. It would be really hard to draw a line, I think.
Yeah, if it's in a public GitHub repo, it's not. That's not. But you know what? The FBI shuts down websites all the time. Federal agencies do all the time.
You certainly should have the right to seize anything and everything. I mean, think of like Hell's Angels; they seized the trademark, right? And it's a valuable trademark. I think the feds resold it at some point. That's right.
The technology, the IP is their product. It's their greatest asset is going to be the IP. So even owning the trademarks or taking receivership of the trademarks, the copyrights, any of that, I mean, it's a product. I mean, that's a very valuable product for them.
It is. Just the caveats I would add is, one, you can download, it costs $0 to copy a piece of software for the most part. Yeah. Two, most pieces of software are really hard to operate. So someone else's software code is kind of like a tarball to a third party. So that's the caveat to that. But certainly, if you have access to all that code and all the Amazon or whatever cloud they're using, whatever systems they have, if you have access to that, you can download the data and do at least the equivalent of getting the file, right? So that you would probably need the rights to access and take all that, but it doesn't solve the Hydra problem itself, but it's a great idea.
But to be honest, you'd want some due process with all of that.
Yeah, you can't obviously go around seizing. Yeah, you have to prove that the Hell's Angels committed murder, and
I think Heather made a good point there about like most of the actors are going to be trying to do the right thing.
Absolutely.
They just need to know what it is that they need to do it in the right way. And if there are ways for reporting bad actors, if we have built those mechanisms, then perhaps the action that follows that could be designed based on whatever that infraction is. If seizing code or if we're seeing more as a deterrent, then there are always going to be bad actors who are trying to find ways around all of that. So when we design the overall system, if there is a way to report and way to get to it, we can focus more on about the good actors and what we need to get them to innovate and contribute.
Yeah,
do that.
if you asked me to, in 15 minutes, I could figure out a way that you could design a system that could not be attributed and could not be seized, you know, through hidden Tor services and you know, Git repos that won't die.
Hidden Tor services is what?
Okay,
The deep web.
maybe we should start thinking about any recommendations we want to bring forward, if there are any, and also what the assignments we're going to look at for next time.
What are the open questions that we have before us now, and what are the research assignments that we would need to do for the next meeting, which is in April?
I would like something more about that privacy by design encryption system, more information about that, because I think that is an excellent way that we can work on protecting confidentiality. And we can sell it to the vendors by saying, look, you know, you don't have to worry about privacy issues at that point because it's all encrypted.
Yep. I'll volunteer for that because
Thank you, Dan.
it's right up my alley.
I was just looking at you.
Yeah.
Could you just summarize the scope of the assignment?
Yeah, to educate us about the privacy by design and the use, how a technology company can use encrypted data and still perform its services without creating too huge of a barrier to become a barrier, really.
Yeah, I guess that's the related issue. I think I read in Kevin Moore's memo responding a concern about the cost. And I just wonder, this end-to-end encryption that you're talking about, what kind of cost are we making it so expensive that the entity is not going to be able to afford to do that?
You can actually do it entirely off of free software today. We do. We use, we use free software to do it.
You just cover that in your assignment for next time.
I think related to that, and this might be either something for plenary or that we might want to raise with the ethics committee, is one of the concepts I know that we talked about last time was that as part of the certification process, you would agree to subject yourself to civil liability and the ethics rules. And last time we focused more on confidentiality, but this time in our earlier discussion, conflicts came up a lot, and looking to whether the conflicts rules need to be modified to take into account the fact that some of these legal providers might be providing the same services to opposing parties, to the court even, and whether there need to be exceptions or not. And I don't know if that's within our scope, but it's
I
certainly
guess the question is, if there is end-to-end encryption and they're really not, it's encrypted, there's no real conflict issue, is there?
Why don't we?
Here's my
Why
suggestion.
don't we get me together with one of the sort of, you know, rules experts, and I can sort of learn about the root of conflict issues. And
I would.
Yeah.
That's
Okay.
me.
Excellent. Okay. Wonderful.
The one other issue that I have, and I thought maybe it would be good for the rules committee, is this concept of regulating a firm versus regulating an individual lawyer, and why is it that we're only doing lawyers, and what are the pitfalls, if there are any, to regulating an entity in this process?
So
No, I thought that was more of a question for the rules committee, but if you, okay.
I'll make a
So
note.
that actually mirrors one of the questions that I had in my assignment. Is there authority to determine and assess a fee, either upfront for registration or you know, through civil penalties? Like, what authorities do we need? Do those exist?
I think we're thinking of a new statute that would provide that, ready?
Really?
Okay, so yeah, so new statute, that kind of covers it. That's fine.
Can't we do it on a purely voluntary basis?
I don't know.
If you want this, you pay.
I'm not a lawyer.
I mean, do we have to have a statutory authority to do it? Every time we say we need a statute, I kind of go like this. It makes me a little nervous before we
I know,
really
but
get it.
remember, we did that in our first session. We actually had that same reaction. And then we said, you know, the legislature should be involved in this to some extent.
I think they'd
Because-
like this.
Yeah. I think it's good. I think there's so many social issues that are at stake because it's not just about the regulation of the bar, it's about the regulation of these legal, of the law, right? Because if you think of it from a design perspective, it's one system, right? Whether it's the family law system, whether it's the tort system, the idea is even though it might be dangerous in some ways, the idea of getting a legislature to consider this, we think has a social good to it.
Well, and you can't have the safe harbor effective without.
You can?
Oh, the statute's got to
Right.
say
It's
the
not-
state bar is not going to
not just
prosecute.
you.
Well, it's
You
not
can't
us
just
who's
have-
prosecuting, it's DAs, and it's not.
Well, no, it would be the Office of Chief Trial Counsel
Well,
on an
current-
administrative level to remove the certification.
Right, but a lot of UPL prosecution's criminal, so, which we have nothing to do with. So if you were gonna provide true protection, you'd need.
Both.
Change the law.
Okay.
I would remind folks that the legislature has appointed members to this group also, so they are interested, right? The Assembly appointed Joanna Mendoza, I'm pointing here because she was sitting next to me, and Margie Estrada from the Senate. So they are very much interested in this issue and wouldn't be surprised if something that we came up with ended up with legislation.
I had one question, but me, so this is probably falls under the encryption area, but it's an audit trail for a system's performance and the outcomes for that. Would we want to require some level and some time period, and would that be part of?
Yeah, and those are, some of those are actually laid out in the LCCA.
They are, okay,
Yeah.
so we can adopt or those in. Okay.
So I guess are we in agreement that the LCCA recommendation plus is the way we're going to recommend it?
I would agree that we should start with that and supplement it, and then maybe not give them monopolistic power over setting it, but certainly accept it as a
Yeah,
one.
with the state bar retaining the jurisdiction
Correct.
to make the choice.
Yes.
And really quickly, just the 7 members, it's Clio, Direct Law, Rocket Matter, Net Documents, Calendar Rules, Next Point, and On It.
I have only heard of Clio.
I've heard of 3 of those, Clio, Rocket Matter, and On It. So, yeah, I can tell you we're going to join, or try to.
Do we want to review, somebody else would like to review that from this perspective of, an additional, sort of a second look at it, to see if this.
Yeah, it should have more than
Sounds like
that.
it's right up your alley, Mr. Chairman.
I could take a look at it. I will not be there at the next meeting, but I can submit.
review the LCCA.
If I can help you in the
myself.
process.
Okay, yeah, let's do that.
How
your
active are
assignment
they?
for the
I mean,
next
I'm
meeting?
just looking at their website, and I'm not seeing anything.
Re-review the LCCA.
Nothing's been updated in 2 years.
from
Yeah, that's
now
what I was
that
gonna
we
say.
have,
I mean, 'cause I-
identified
You
as a
know,
possible.
we're very
way
involved
to
with
offer,
ILTA, and so one of
to
the
see
things
if
I'm
there's
trying to
anything
find out
that,
from our
Oh, hold on.
CIO
Okay, we can only
is.
have one conversation at a time
separate.
because there's closed captioning for this meeting. Abhijit, I just need you to clarify your
Yes.
assignment is to re-review LCCA.
Abhijit and Joshua.
And Joshua,
Yeah,
okay.
we will review the LCCA as a second independent look. From this perspective, it will either be the foundation or parts of it could be used in our.
So maybe you could do kind of a pros and cons. These are some of the
Right,
strengths and
right,
weaknesses
yeah.
of this possible option.
Right, and also relevant and irrelevant
Good.
aspects of it. too.
Okay, thank you. I'll take
And you
another.
might be able to put together alternatives too, potentially.
Oh, right, yeah, okay. We can explore that.
Because we're getting hit with a lot. On the RFPs that we're getting from different companies out there, we're being asked to subscribe to, fill out certain forms. So I'm trying to find out, right now through our head of technology, are there standards? I mean, besides ISO, that we're being asked to fill out forms and, confirm that we're.
Would it be possible to get feedback from law firms about this issue?
Yeah.
If you could help us with that. that'd be
Yeah,
great.
absolutely.
The security standards.
Because we're asked to fill out security standards for all the different companies that we work with. So whether it's banks, different financial organizations, other organizations, we have to, fill out all of their forms. So I'm trying to find what standards we're being asked to do.
I think they're mostly ISO, aren't they?
No.
SOC Type 2 data center.
I can ask
That's
my
mostly what it is.
my ex firm. He speaks quite frequently on this topic. I can ask him.
That would be wonderful.
Steve Pushes. I'll
Almost
ask him.
like a light survey almost, you know, but it'd be great.
Okay, Heather,
One-
can you just reiterate what you're, sorry, I'm trying to get this all down so we can go into your assignment memo.
I'm just gonna check to see what the law firms out there, we're being asked to, fill out and confirm our security standards. So I'm going to go out there and research what the law firms are being asked to do by the different industries out there, so whether it's financial services and others.
The security standards are different.
One area that I thought might be right for either an assignment or further consideration was to do with Randy's memo to us about the legal device, the legal advice device model of regulation. At the last meeting, we seemed to focus more on regulating providers versus the actual technology, and I don't know if there's an assignment there in looking at how the two different approaches raise different pros and cons with respect to access and protection, or if it's something that we should just consider and be ready to discuss and make a recommendation on in the next meeting.
I'll take that up.
Yeah, okay.
Can we get a presentation from Randy next time too on that, or is that, if he could walk us through, if it's not, just a thought, it'd be nice to actually have him walk us through the idea and.
I actually think he wanted to do that, and I'm sorry that he left because I think, he was interested in doing that because I think he wants to pass that off to this committee, that it's sort of in your bailiwick.
I'd really like to hear from him because he's. Yeah. It's also his experience as well makes it a little richer conversation. So maybe next session.
Sounds like a
So really quickly, there were just a few other questions that I had from mine.
Attention all state bar staff. There is a network issue affecting many network PCs. IT staff is coming to all floors to check every PC. Please do not turn your PC on or off until IT arrives. IT is working floor by floor and hopes to reach everyone within an hour. We apologize for the inconvenience.
Sounds like a breach. That sounds like ransomware.
Really? I literally saw somebody running past there.
That's
Yeah.
a breach, probably.
Yeah.
That's crazy.
But it
Lovely.
underlined.
Okay.
Yeah, right?
Timely memo.
Yeah.
Well, I'm in the network.
Well, we're on the public network, so that should be fine. I think
Yeah,
they're
you have
probably
just getting internet access. It's
problem
not-
with the
we're not
intranet
networked in.
network. Is that what it is?
There is a network issue affecting many network PCs.
What does that mean? I know
I think
staff
the
is
airplane
working
mode is
all
sounding
floors.
disconnect from the network.
IT is working floor by floor and hopes to reach everyone within an hour.
Get off the net, get off the internet?
So,
Okay, we'll just shut that down.
okay. So, with respect to the sort of interview process, there was like I was thinking, should these be essentially open meetings, or are they more confidential meetings? Like, do we model this off of like more of a disciplinary process, or off of is this of interest to the public, and where does that balance lie?
Current admissions process is not public, right?
I would think.
But the disciplinary process, once charges get filed.
Wendy, microphone.
Oh. The admissions process is not public, right? It is confidential right now.
As far as I know. That's a Donna question.
Okay, could I ask not to discuss about what we heard of it? Because
Sorry.
Every word is being transcribed on the web.
Okay. I'm asking about admissions process. Right now, is that a confidential process?
In terms
Microphone? Donna, microphone.
So in terms of the moral character, which piece are you talking about?
Yeah,
I guess
so
any
like
of it.
The moral character review. I mean, I guess if there was some sort of, the bar standards or the score, whoever sets the scoring level.
The testing standards?
Yeah.
Okay.
So that, I mean, that's public.
Yeah, so there are basic standards that are public, but as it applies to any individual person who's applied to take the exam, what their score is, whether or not they have been determined to have the requisite moral character, that information is not public. But what is the passing score for the bar exam? That's public. What's the grading process? Maybe. I need to think about that one. Actually, the grading process may not be public. But a lot of the processes are, to the extent that they don't reveal information. The bank of bar exam questions, not public. So it's just to the extent that it could impact the integrity of the bar exam or go into the sort of confidential information of particular applicants, that would be confidential.
I mean, you have parallels in that, like, there's very likely sensitive, sort of trade secret information.
Right, yeah.
Obviously, that could be protected in some way. If there's a new statute, that solves a lot of problems as far as protecting that stuff. But should it be protected? If so, how? Is the meeting by default open or closed? Is it open with a sort of a closed session where you talk about the trade secret stuff?
We don't want a company to feel less motivated to engage in the process because their business strategy might be revealed during the process.
They don't want
But
to feel
if
like
you're
they get their
serving,
IP.
if you're serving 1 million customers, maybe that rises to the threshold where that is public interest.
I think it's
20 million.
I think we need a nuanced handling of that and whatever the final recommendation is, because if they feel like they're having to give up their IP, they're going to go into a different industry or avoid it or something. But if you think about hearings on different regulatory areas where they've got the public element and then they might have a closed session for something.
Mm-hmm.
Or if you're filing something for the SEC, you can redact.
Right.
You have to make the case for that, right? So the other tool we have is we can have this sort of, there can be a certification which is done by a third party, and that may be secret, right? But anyway, that's a great point.
At this point, let's recap the assignments and who they're assigned to, so we know what lies ahead, and then see if we're missing anything.
So far,
I have one more.
Oh, one more question?
Yeah.
Okay, let's have the question first.
So as far as selecting the panel of reviewers, these were at least conceived to be sort of like a panel of, say, 3 reviewers, 1 lawyer, 1 technical expert that's not conflicted, and I'm sure there's a conflict policy somewhere that's usable, and some other relevant person. How would, do we allow a company that's coming in to go through a review to see those members ahead of time? Are these appointed members? Is there, how do we handle, do we let them preempt certain reviewers? I shouldn't be allowed to review another contract review company, but if my name's out on a website, that solves a lot of problems. People can say, oh yeah, not Dan. But if it's sort of more, if these committees are more put together ad hoc and you don't know who your reviewer is until you get there, it's harder to object,
So I think, have we resolved the question of whether we really want these folks to be private or full-time employees of the bar, assuming funding exists, right? Which I'm not, but have we resolved the question of who this class of individual who's going to be on those committees?
No. In this
theory,
document,
they could be
there's
private.
a proposal.
Right.
Certainly no decision yet.
I think we might be getting ahead of ourselves a little bit to start trying to formulate who's going to be on this review panel.
detail.
Just the fact that we have a review panel could be a recommendation. Now, going into how many people should that panel be made of? how many of them should be lawyers? How many of them should be tech people? Should they have a conference? That might be a little bit getting into the weeds, I think. I think we
Great.
need to focus on the bigger concepts
Let's
here.
table that.
I mean, we can maybe circle back around, but right now we haven't really come to any solid conceptual recommendations that we could bring to the committee, to the entire task force that what we might want to consider.
So it's not a research assignment at this point, but it seems like the main one to take away from that is that it needs to be a balanced panel. So that's a good thing too.
So one thing that I had worked on last time was, checking, how would the bar hold someone who is not a licensed attorney accountable, an individual? And it was basically, there really isn't a way for the bar to be able to hold an individual accountable. But my question, I guess, moving forward, and maybe something to look at, is if we are going to do this, why can't, if there is going to be a legislative change that has to go in, that whoever the individual is, the president of the company or members of the, the board of the company, have to basically, put themselves under the control of the bar, in regards to this. One of the things that I would want to know is that the president of the company, the people who are running it, the officers of it, actually know and understand the bar rules that apply to this company. When it comes to the advertising rules or the ethical rules, just having some lawyer on the side who signed off on it doesn't mean that the people who are now running the company are going to be running it in conjunction with the laws. So I think Johan, who was sitting here, mentioned that he's not an attorney, but he's licensed by the bar. He's not licensed. He's a member of the state bar of where he comes from, his state. And so I want to ask him questions about that, because that could be very interesting if now you make lay people have to become members of the bar, and they basically have their own little mini exam that they have to take.
So Heather, your idea is almost like we could potentially submit the C levels, for instance, as an idea of the legal process organization. You could have another category that could be a legal engineer, right? You could actually certify people. And that could benefit them, but it could also subject them to discipline or civil liability.
Under Sarbanes-Oxley, the CFO signs the financial statements.
So they have criminal liability.
It's a model for that.
Yep, it's a great idea.
Yeah, I think you just need to we'd need to think about what would the bar's remedies be, right? So if we are regulating somebody, it's easy to discipline them, to discipline somebody who has a bar license and to impose conditions on that. So it would just be a matter of what would it mean for them to subject themselves to the bar, and what would the enforcement be such that it would be it would have any teeth.
Right.
Man, you guys are going to make me join the bar.
All right, let's recap the assignments for next meeting.
Do you want to do a tip break?
I've got the first assignment. This is for Daniel, to educate the group on privacy by design and explain how a tech company could use encrypted data in its machine learning processes, what that would look like, and both how that's possible while maintaining encryption and also without becoming too huge a barrier to entry, how that standard would work. Dan will also, and we'll talk with Wendy about this, look into whether a rethink of conflicts would be needed if there were a standard here, whether there's a danger of sharing amongst parties to a specific piece of litigation or a specific dispute. Assignment number 1. Assignment number 2, Abhijit and Josh are looking at basically re-reviewing LCCA as a possible standard, and with an eye towards whether possibly making a recommendation on that at the next meeting. Heather's going to get feedback from law firms on the security standards that they've been asked to use and what they are using. And Wendy is going to look at the pros and cons for access and public protection for the provider regulation approach we've talked to for the most part versus legal advice device regulation as described in Randy's memo to us. And that's what I have.
Did we miss anything?
I have one more question.
Okay.
Sorry.
We'll go back to the questions.
So I have sort of an unresolved ethics question around, essentially around privilege. From where does privilege flow? And essentially, can we / should we figure out how to extend privilege to technology providers.
Okay, I guess my question to you is, why would they need a privilege?
To resist subpoenas on certain grounds.
Oh, it's interesting. Because most terms of use I've seen for technology companies, for law firms, they basically say if I receive a subpoena, I have an obligation to give you notice, client, so you can file whatever papers you need to do to protect your rights.
Unless it's a national security letter, and then it's got a gag order.
Well, I've never seen that exception.
Yeah.
But privilege is an evidentiary, yeah, it's an evidentiary concept, so it only comes up in issues where evidence is being used. So a subpoena is probably the only way. But I guess I'd have to think about that. What would be, why would you need to provide a privilege to them? And what are the downsides to that if you do?
The
I mean,
background radiation, oh, go ahead.
It would be a seismic shift to provide privilege to a corporation.
Yeah,
Like,
I can't
that's a
imagine that
scary
would,
thought, right?
yeah.
But
just because of the nature
there's a
of
valid reason for it potentially on a civil liberties ground.
I know, you mean imposing a duty of confidentiality?
No,
Confidentiality on?
allowing them to shield the information under the
Based on
ADJOURN privilege. I'm not sure you need it.
Yeah, I'm not sure what I think Wendy touched on this, but if you look at privilege as an evidentiary type role, person, I don't think a person has waived privilege by sharing some information, certainly not with Westlaw or, a computer program that has, that's intended to be and remains confidential.
Okay.
I don't see any waiver of privilege issues in using something like that.
The background radiation for this is the privilege inhere is in the client. So Brady's point is almost that it should inhere in the data. What's missing in our scenario is there's no lawyer anymore.
Right.
So there's no communication to a lawyer, so there's maybe no lawyer at all in some of these scenarios. So I think it's worth asking the question, even if we might not want to have a pat answer for it right
Yeah,
now.
I just think of it as, okay, as a consumer getting a legal service from a human provider, they get privilege. That's one of the benefits, huge benefits of using a lawyer. You get to have a trusted professional work with you in a confidential manner. If you then shift that service, that legal service over to a machine, you no longer have that.
So then if I file my divorce that way, theoretically, my opposing counsel could subpoena and get the entirety of the information.
Yeah, and as a provider, I get a subpoena. I have to turn that over, and it's not really any way around that.
I see what you're saying.
Yeah, I see the issue now because if there is no attorney there.
There's no attorney.
Yeah. But if the data is encrypted from the very beginning and you don't have access to the data,
right?
What do you have to give them?
Maybe
maybe that's the other answer is that they can't get access to it.
Well, but then you put that
It's
person
a
on.
communication that's being protected, a communication between a lawyer and their client. I'm not sure if you're interacting with the technology, whether you're communicating with the technology, you're providing information.
Right.
And one of the other things that's important for non-lawyers to understand is that just because you communicate a piece of information to your attorney doesn't make that information privileged.
Right.
Oh, I'm sorry. Doesn't make that information privileged.
It's the communication with your attorney.
Right.
It's that
So,
link.
yeah. So I mean that I'm not sure it really translates to that scenario where you as an end user are giving information to a technology that would be considered a privileged communication.
Okay.
But I guess the question is whether it should be if it becomes.
Yeah, but
I'm telling you all this, and now I'm going to get advice back from you, computer, and then I'm going to be put on the stand and asked. Oh,
Here's the risk.
Yeah.
Here's the risk. If there's no privilege and people understand that, they won't tell the computer anything.
A good scenario, I'm just thinking of one of the technologies that was demonstrated to us. Do you have a tenant-landlord issue? Yes. Do you have a lease? Yes. Does your lease prohibit you from using illegal drugs in your apartment? Yes. Did you use illegal drugs in your apartment? That becomes a privileged communication.
Yeah.
The fact that you.
Yeah,
did.
or, hey Siri, where do I hide a body?
But if it's encrypted.
That shouldn't be.
Well, that
But
should
tip
be.
privilege.
That's
That's a good example of the opposite.
That is one of the exceptions.
Then the computer automatically reports you to the,
No, but my question, if it's encrypted,
Yeah.
you wouldn't be able to call. So you get a subpoena. I want all information for Wendy Chang. You type in Wendy Chang, and all you know is I paid you some money.
Yeah.
You can't
So-
connect it with
so
anything
that-
else.
That might
That might be the way to
circumvent the
do it.
problem. Yeah.
Yeah.
That's a fascinating discussion point. We need to wrap up here pretty soon for the next segment here. So I think we identified 4 assignments for next time. Is that correct? Okay, great. And then we have a list of open questions sort of that we discussed. And definitely need more time. Perhaps this could be put on the agenda for the next subcommittee meetings, at least some of them, if we think they're worth discussing more. So any other items that we need to discuss? I'd like to give us a little bit of break before the next segment.
I think I'd just like to say that eventually we need to start refining all of our discussion into some solid recommendations. Not necessarily have to be very specific, but we need to, I mean, all the discussion in the world is great, but I mean, we're expected to produce some kind of recommendation to the full task force for them to consider as well. And unless we don't come up with anything, I mean, we can present, a summary of our discussion, but they're gonna ask, so what?
Right.
Can we create a skeletal outline of what we need to do? Like, I'm not talking about the recommendations yet, but I'm just talking about the topic headings.
Yeah, is that something we could put in the next agenda? Like, here are the 4 areas where we think, based on previous discussions, we can
Just to know that what
develop a
questions we're
recommendation.
answering. Yes.
Yes. And then further on, further down the road, we can separate those that will become more recommendations and those that we leave for future next task force to take on to further build onto that. So things we cannot tackle within our scope here.
Sure, we can do
But
that.
so I guess maybe yours and Wendy's and my task is for the next meeting to identify what those
Yes.
areas are, so that we can
That
sort of
would be a
hit them
very
more
good idea.
methodically than
Great.
wide-ranging discussions, which are very helpful. But
We could spend decades
Right.
dealing with some of the stuff. So
Okay.
it's good.
Right. So do we have everything we need to finish for this subcommittee? Is there anything else that needs to be covered? I think in the main plenary, we'll present our assignments and
And a summary of what was discussed.
Okay, so let's work on that. But yeah, yes. All right, so we can end the segment here and take a little bit of break before the 2 o'clock. Thank you. We need to then chart the path we need to take. But it's a vast one. It seems like to me, at least from a technology perspective, the technology aspects are the easiest to tackle in this. It's the legal aspect of the legal perspective, regulatory perspective that's more challenging. But like you said, yeah, you can do machine learning or encrypted data. There are technical problems that you think are problems can be solved or will be solved eventually. It's these other larger issues that have been around for 100 years or more as what we keep encountering again.
I'll put together for computer science group that I teach. I have a demo of it. I can throw a machine learning tool in there and show that it uses all open source tools and all that. Use that.
The system has detected that a minimum number of lines are connected to this conference. Do you want to continue your meeting? Press 1 to confirm. If there is no response, the conference will end.
Is anyone on the line?
Your call cannot be completed as dialed. Welcome to Reservationless Plus conferencing and your Thank you. You will now be placed into conference.
Are you guys on the line?
Can you hear us? We need to reestablish it on the phone. We'll start again with another roll call.
Hello, yes.
Just to bring us back
I don't know.
Chicago group
Yeah,
here.
of course. But can you guys hold on? I'm trying to see if there's anybody. I'm trying to see if there's anybody on the phone, but it's too loud. Okay.
Hello.
Oh, they are on the phone.
Okay, we're going to get started, and just so that, because we've got some folks, I think, from afar, we're going to go ahead and call the roll again, just so that we know who's participating and how we should proceed on any sort of action vote that we end up having to take. So, Mimi, would you mind taking the roll again, please?
Yes. All right. Justice Edmond.
Here.
Toby Rothschild. Here. Joyce Raby. Here. Andrew Arruda. Here. Simon Bohm. Tara Bird. Here. Judge Wendy Chang. Here. Abhijit Shaban. Here. Jean Clausen. Valerie Dean. Johan Droshagen. Margie Estrada. Lori Gonzalez.
Here.
Bridget Grammy. Here. Andrew Kuchera. Joanna Mendoza. Here. Kevin Moore. Here. Heather Morse. Here. Daniel Rice. Here. Ellen Rodriguez.
Here.
Dan Rubens. Here. Mark Tuft. Here. Joshua Walker. Thank you.
Okay, thank you all very much, and thank you, Lori and Alan, for joining us again. I take it Jean is not with you anymore?
I am. I'm still
Jean.
here.
Great. Perfect. Okay, well, I think we had some lively discussion, and we look forward to hearing from the various committees. So, who wants to go first? Okay. Tara, your rules, yeah?
Rules. So we focused on 2 rules, one of which is not even a California one. That was ABA Rule 5.7. And that, I don't actually have it in front of me. I don't know if anyone else does, if we want to read it. But it's the short version of it is that lawyers will be subject to the professional rules of conduct with respect to law-related services. And there's kind of a carve-out there where if a lawyer by themselves or with a non-lawyer notifies the public that, I'll just read it, in other circumstances by an entity controlled by a lawyer as an individual or with others, if the lawyer fails to take reasonable measures to assure that a person obtaining the law-related service knows that the services are not legal and that the protections of an attorney-client do not exist. It's kind of a poorly written rule, but the carve-out would essentially be that as long as the consumer is provided sufficient notice that there's no attorney-client relationship, that the rules would not necessarily apply. So we had a significant discussion about this, whether it's necessary, whether there's any value, whether it actually would increase innovation, whether it actually would increase access to justice. We did not have any conclusions, but we did have I don't know, it's not an action item, but we did have a request, which is that there are other states that have implemented it or versions of this. And we would like to ask Joyce for assistance because we were informed that you had contacts.
Okay.
And we want to know from these other states who have implemented a similar rule, has there been any perceived difference or improvement in the access to justice for those states as a result of this rule?
Yeah,
So-
we were looking specifically, you mentioned you've been in contact with folks from Arizona and Utah who do have the rule. They have a task force, they've impaneled a task force similar to ours, and they might have some insights that they might be able to provide us.
And I'd be happy to follow up on that. It's not stuff that I have off the top of my head, but yes.
Okay, thank you.
Would love to.
So we're just sort of more data collecting on that value, and one of our thoughts was we don't want to rule for the sake of a rule, but what difference would it make, pros or cons, what value would it add? And then we came back to something we discussed last week and mentioned, which is what's really stopping attorneys from innovating, and something we hoped our survey would answer. Is it really fear? Does this alleviate fear? Because that's something that comes up constantly, some of us projecting our own insecurities as an attorney. Or is it just P&L? Is it really just about the money? Or are attorneys just disinterested? So, as we're discussing these rules and the effect they might have on them, we're still kind of anxious to really understand why attorneys are not doing more innovation. That was kind of it for that data collection. The only other rule we focused on was Rule 1.1, which is competency. And Andrew put together a memo for us on that. And the first question I asked was, should the black letter law change to reference the word technology in some form? And our group did not agree that the black letter law should change. But they said that if it changed, that competency in technology should be mandatory, that the word shall should be used. So if it's going to be in the black letter law, they said it needs to be a requirement and not a suggestion. But what our group did agree on was that we should have a new comment. And we started with ABA comment 8. And we do have an action item relative to this comment. I'm not sure how to share that.
This is comment 8 to rule.
This is comment 8 to
1.1?
the ABA. Yes.
Okay.
And I think it would be comment number, I don't know.
Would probably end up being comment 1 because the other 2 comments are just cross references to other rules.
Okay. So it would be a comment to our rule 1.1. And I'll just read it for you and then give you some of our thoughts. The duty set forth in Rule 1.1 includes the duty to keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. We have another phrase after that we disagree on, or we did not come to a conclusion on, which is the phrase relevant to your area of practice. Should the competency of technology requirement just end at relevant technology, or should it include only relevant to your area of practice? And so we made a motion to bring a formal proposal, which I'm not sure how we go from here. We also discussed in that should we include the word innovation? One reason to include it would be because using words just subconsciously encourages attorneys that this is something they should be thinking of. That was also one reason for having the comment on technology to begin with. Ultimately, we felt that innovation was too vague. Mia said that was too hard to enforce. What does that even mean? We discussed endorsements, and I think ultimately decided we didn't really want the State Bar endorsing anybody or endorsing particular products because things move too slowly. They might endorse something today that's outdated tomorrow. That could be a problem in antitrust issues. But then we discussed soft, indirect endorsements, which would be having an opinion say something like, as long as problems A, B, and C don't exist, then most likely that type of product would be successful. sort of checklists for compliance and what to do or what not to do. And we also discussed, certifications and how that might work. Just a few phrases that came out of our group. One was that if our rules are geared towards innovating, it will likely have an effect of encouraging attorneys to innovate. So just using words like technology tells attorneys it's okay, you should be thinking of this. And that public protection means increasing access. We sort of kept approaching everything by how to control it more, when sometimes we just need to, stop controlling. We also discussed whether we want to propose that there be a mandatory hour of technology-related MCLE. We did not have any conclusion on that, and that may also be an alternative if people don't like the comment idea. But we thought that might be difficult to regulate, and that there are lots of technology-related MCLEs that people have access to. So it may not be, if it's necessary for your competency, to follow the rules, that you might not need to be so specific to require the hour MCLE on that topic specifically. So that was it.
Okay, let's do it this way. Anybody else? I can see the two down there ready to go. Let's do it this way. Is there anybody else from the committee who would like to add to that summary? Yes, Andrew.
I'm not on the committee, but just to assuage whatever comments might be coming. The subcommittee voted to recommend an addition to the California Rule 1.1 to add a technology component, and they will be drafting that up and bringing it back to the full group to consider that at the next meeting. So you don't have to solve the problem right now if you're going to make the comment. I hope that was clear, but that's basically what occurred at the subcommittee.
Okay, so you're not making a motion today for action. You'll bring it back to us at some point in the future.
Yeah, so we're drafting it to bring so everyone can review it for the next meeting.
Okay, terrific. Anybody else from the committee want to add anything before we hear from others? Kevin.
Yeah, just to clarify, when Tara was talking about in the alternative on the MCLE, the concept on MCLE, it was suggested that if there were a change to the rule, you wouldn't have to require that anyone take any MCLE on technology. If someone saw that you have a duty to be aware of technology and have an understanding, that would automatically become part of MCLE, and people would be taking it anyway, that you don't really need to do it. If, however, the comment were rejected, I mean, if it got all the way up to the Supreme Court decided not to adopt such a comment, then perhaps you would want to revisit the issue of MCLE requirement.
And I just want to add that if we adopted the comment, we would be the 36th state to adopt a comment relative to technology, but we'd be the first step to make it a duty and not a mere suggestion.
Okay, anybody else on the committee? Okay, Judge Chang.
Actually, I only have a few comments. The commission, when they put together their work product with respect to recommendations for the revisions to the rules of professional conduct, we were under a direction from the Supreme Court not to put in anything aspirational into the rules. And so we shouldn't be putting anything in there to encourage people in a soft kind of a way, because it has a lot of effect downstream, one of which is people tend to use that. They use it in malpractice lawsuits. They use it in, there's a lot of ways that it is used, and the industry as a whole is not as sophisticated as it should be in technology use. The industry, I think my generation was the last generation that didn't fully use technology from the get-go. I remember in college, we were still typing our papers. And so, and I'm not going to say how old I am, but I am. There are people in the generation still actively practicing who are older than I am, and they're not that comfortable with some of the newest phases of technology. And so when we talk about what we want to require as opposed to what we want to encourage, I think we have to be very, very careful to take into account the entirety of our legal population and not just the younger generation that are very, very comfortable with technology. The second thing I wanted to say with respect to the comment 8 of the model rules, the California State Bar ethics opinions, the technology opinions, they already adopted that comment pretty much as written. And so that standard is kind of already in the law of the law of lawyering right now in California without changing of that language. And I would be against limiting that to your legal practice because that leaves a whole, I think that leaves a whole area that people might be using technology that might affect the practice in such a way if you're not requiring them to be competent with that, but it's outside of their area, their specific area of practice. I just think it's a weird kind of a, it's kind of a weird way of kind of limiting it, which I don't think is going to have any positive effect and has potentially a whole lot of negative effect. And the last thing is, at the last meeting, I came away from the last meeting thinking that we were all kind of talking about this potentially new, it's just me, a certification program that would allow some kind of a safe harbor for technology companies to operate in. What I'm hearing from you now is that you guys are against that idea, and that confuses me.
First of all, that was not our committee, so we didn't ever, that's not something that our committee is even really discussing, right? That's coming from a different committee. We're not talking about certification. We're looking at the rules that currently exist.
Okay.
And also, we didn't talk about that. We literally, I don't think this rule, our suggestion, has anything to do with that.
Okay, because your comments about the state bar should not be endorsing or anything, that's what got me a little confused.
We were just, that was just a discussion about competent products, like what type of, like if you were to use a new product, is this endorsed by the state bar or is this certified by the state bar as being a product that is meets the competency requirement? That's what we were discussing. Does that make more sense? Like for example, if you use Clio, which now a lot of us do, is that safe? I don't know. Is it safe? Everybody uses it. They say that they're safe, but might the state bar find differently? Well, one way we would know if their state bar is okay with it, that I'm not violating my rules of competency, might be for them to endorse it. But we decided we don't want them to endorse it. Well, maybe it would be for them to say, well, as long as a product meets certain requirements, it's encrypted, then you're fine. Okay, that might be a way we know that we're meeting the competency requirement, or a certification for a particular product. Okay, this product is secure. It's been vetted by attorneys. It's relatively reliable. Whatever. Okay, it meets certification. So that's how I was using those terms, just as to products.
I'm going to let Kevin weigh in on this, and then Mark, I do remember that you want to speak up.
Yeah, I think we viewed the concept of endorsement and certification as two different things. And we immediately recognized that the AI UPL subcommittee was addressing the issue of certification, and that was hands off there. But it's just coming out and say we endorse this product, to me says something different than having somebody have a certification issued by the state bar. I think there are two different things.
Mark.
Is this on? Turning to the 5.7 issue just for a moment. 5.7 was adopted by the ABA in the 1990s to deal primarily with a small facet of what we're dealing with, law-related services by lawyers who are engaged in the practice of law, and how to draw lines between services that would be governed by the rules and those which will not be governed by the rules. Although I'm in favor of 5.7, I'm hoping that the recommendation will be that if we look at 5.7, we don't have to take it as it presently is. It actually is a good model It has a nice framework to it that allows us to do some maybe tweaking to it or perhaps some additional comments that will bring into play the advent of technology and innovation and artificial intelligence as it applies today in various settings. And we talked about that in our practice, in our subcommittee too. So I'm hoping the recommendation would be that we do study 5.7 with the idea in mind of a futuristic application of the rule and not just the way it's been modeled so far, because frankly, in some respects, it may be a little bit outdated.
Just a quick note, we agreed.
Any other discussion from anybody want to weigh in on any of these topics? Terrific, everybody. Terry, does anybody come away with? Yes, Andrew.
I just had maybe a point of clarification. When we talked about, in your last point there, about that California would become the first to make that type of tech competency course mandatory, what was the language? Because I know that Florida and Wells, the North Carolina State Bar, has something around tech competency LE that's mandatory.
No, it had to do with the comment. This is my understanding, is that we'd be the first to have that in a comment, not that we'd have a class.
Okay.
But that it would be a duty as opposed to a suggestion.
Okay, yeah, because right now, maybe just for everyone's knowledge, Florida as well as the North Carolina State Bar have passed and have mandatory tech CLE already on the books.
Wendy?
I don't think you can put a duty in a comment. Can you?
Kevin?
The Supreme Court did. No, the Supreme Court did it in a circuitous way with Rule 1.2.1 by cross-referencing another rule. What this rule does is it clarifies what the competence rule, which is generally written, what it includes. And all we're commenting on is saying that the duty that's described in Rule 1.1 includes a duty to keep abreast of, advancements in technology and the like. So we're not actually mandating it, but we're just clarifying that it includes that. And that's no different. We actually took the language from former Rule 3.110 as it applied to the supervision duty.
Randy?
And as pointed out in, I think it was Andrew's memo, California's rule is different from the model rule because it's a rule that says thou shalt not, intentionally, recklessly, or repeatedly, or with gross negligence, essentially be incompetent, whereas the ABA model rule is you should be competent. And so the anchoring of this comment to our black letter is really functioning a lot differently as a disciplinary rule. It's saying that if someone is completely reckless with regard to their understanding or use of technology, well, I think something came up in the other subcommittee that some groups are still using Windows, what was it? Windows 95, which if you connect it to the internet, it will be immediately attacked and crash. That might be an example of reckless incompetence with regard to technology, but catching on to the latest, greatest thing and being innovative, I don't think would trigger a disciplinary issue the way we're working it with our rule.
Joanna?
I admire everyone's, not everyone, those of you who have faith in lawyers to read the rules of professional conduct and follow them and consider them, I think we're better off doing a technology MCLE requirement because that actually is easier to get the attention of lawyers than putting it in a comment in the rules. It is we've kind of thrown it around. We've talked about it briefly at the board level. We haven't quite got there yet. It's been kind of put off, but it's in our strategic plan. And I think a recommendation from this group as to whether or not we should do it would be very helpful.
Just to sort of build on that and what we discussed, Kevin suggested, well, criminal attorneys don't use it because they should be meeting in fields in Iowa to just talk with their clients. Nebraska. But part of this, and also to what Judge Chang said, was just because you don't use it doesn't mean that you shouldn't be exposed to it. I compared it to your core classes in undergrad, which I know some people disagree with, but you need to know what's out there. And we are talking about access to justice. And if you're not using something that could increase access to justice because you don't know about it or because you're afraid of it because you're not familiar with it, that's inhibiting. And so just letting people know you should you should keep up with what's going on. You should be protecting your clients, but it also could have the effect of getting people to, force them to look at what new technologies, what new apps could be assisting them with reaching out to those clients that they're helping. And that would include criminal defense attorneys, or just bettering their practice as a whole, which is valuable to attorneys, not just basic communication.
Okay, Tara, did you come away with some future assignments for the next meeting?
Yes, one will be to build that motion more formally with an explanation and to memorialize these thoughts. And the second is we're going to take the memo that we did last time, and everyone else in the section is going to build upon it. It was brought to the attention that was really my perspective. It was one draft, and I think it might have gone to Kevin, and so really that was two of us sort of putting thoughts down paper from our perceptions of last week's meeting, or the last meeting. But we want everyone to contribute their thoughts so that as we work our way through each of the rules, we have other people's opinions already in there so that we can get through them, because we do have a lot of very, very opposing approaches, which is great, and bringing them together takes a lot of time. And so
Okay.
we also invite anyone else, if you want the Word document, Mia's going to circulate the Word document of that so that you can put in your red line changes, or really it should be your red line thoughts, and then compile them into one, might be very long document, but let's get everyone's ideas in there.
Okay, any further discussion about rules?
I have a question.
Yes, go ahead.
Hi, this is Lori, and I've sort of struggled a little bit with the idea of recommendations for a group, so I think this is kind of a process question. So our subcommittee did discuss a rule change versus a comment, and while we didn't necessarily come away with a decision, we came up with one small thing we sort of wanted to recommend, and then I heard Judge Chang mention she thought everybody on the committee was on board with the certification process, although I'm a little confused as to whether we as a committee actually made some sort of recommendation or sort of decided that as a group. And so it would maybe be helpful to me, and if others find some value in that, getting a little bit of maybe re-instruction on how we're dealing with overall recommendations as a group.
Well, let me take a first stab at it. I think there were sort of multiple parts to that question. With respect to the issue of recommendations, it was not my understanding that Judge Chang was suggesting that your committee had actually made any recommendations with respect to that issue. And indeed, Judge Chang's committee and Abhijit's committee has not yet made any recommendations yet formally on that prospect. I think all Judge Chang was doing, and I shouldn't be speaking for her, but was simply asking if what Tara was saying somehow related to or expressed some sort of view on what had been developing out of their committee, which was sort of something that looked like a certification process. With respect to future recommendations, I think it is within the jurisdiction of your committee to make any recommendations that you would like to this group with respect to whether it's rules or ethics opinions or, as you even heard, the discussion was a CLE suggestion. So I think you've got all sorts of options, and it sounds to me like you are all going down the right track in terms of trying to address this issue of technology, and should it be part of either our formal rules or comments or CLE. I guess my only question for Tara would be, and I don't know, Lori, does that answer your question?
I think so. It gets a little, I understand we sort of have a wide berth, and appreciate that we're all kind of struggling through. We're also on a really short timeline, so sometimes it feels like we're trying to produce something before we've really always answered a question. So just more of a comment, although I think everybody's working their patooties off to do something here. So I'm really encouraged by that.
I would certainly agree with that, and I hope Mimi got the spelling of that down. I guess, Tara, my only question would be, I saw in the materials sort of a chart of a number of rules that might be the subject of discussion of your committee, and I'm wondering, I think Lori's got a good point. We've got a pretty short timeline here. Is there a plan to try to have your committee address each of those in some fashion?
No. So when I put together the chart was built based, I think Randy built it based on the memo. I built the memo based on our discussions and literally by opening up the blue book and reviewing rule by rule to see which one might be impacted by some of the decisions here. But a lot of the nuances of those rules are going to be dependent on what some of these other committees what some of the bigger decisions. Are attorneys involved or non-attorneys? Some of these rules are perfectly fine, it seems, if we're just talking about attorneys, attorney competency, not a problem. But once we start talking about fee sharing, then those rules might be impacted. Even competency might be impacted by fee sharing. So today I picked the 2 rules that had been carved out previously. We started there. We didn't really get further. Moving forward, we're trying to focus on the ones that we can look at separately, but as to how we go through them, not in particular. And some I think are pretty quick, but it's going to depend on other factors.
Thank you. Very reasonable. Kevin, did you want to add something? Okay. Thank you very much to the Rules Committee. Having heard not many volunteers, let me call on AIUPL.
Hi, this is Abhijit Javan for the AIUPL committee, subcommittee. We first reviewed 2 assignments that we had identified at the previous meeting, and I'll call on a couple of members of the subcommittee to give a quick summary, a minute or 2. So Daniel Rubens first.
Sure. So we talked about technology competence, but in a totally different meaning, sort of how technology can be competent and get near or practice law in a manner that is competent. So we decided that, we didn't decide, I should say. We talked about how we could evaluate technology competence. And we thought through a couple different areas. One, whether the technology is meeting the same kind of metrics and standards that you would see in an academic review. So rather than setting a specific metric, like there's a metric commonly used in natural language processing called F1 score or area under the curve. There are a number of different metrics. We could go all day on that stuff. So instead of selecting a specific metric, we said, whatever's going to be accepted by a journal, an academic journal, that would be suitable. And then as far as evaluating the other side of that, having some human control over that, and having a licensed California attorney integrated with the development team, they would be essentially supervising and making sure that the product is producing kind of sane results all throughout the process, and that it gets to a suitable level of competence before it's released. So that covers confidentiality, competence. Confidentiality is next. Again, there are 2 prongs to our discussion here. First was the confidentiality with respect to information security. We looked at 3 different sets of standards. PCI DSS, which is the standard that is required by the payment card industry if you use a credit card on a website. This is the standard they must meet for using a credit card and processing that payment. That is a very light standard. So we also talked about some more detailed standards. The Legal Cloud Computing Association was a standard that we sort of settled on. It goes beyond PCI DSS and covers availability and a few other areas that are important for sort of legal services. And we also covered a much higher level, which is the ISO 27000 series. So ISO 27001 is a very common one. And these impose a lot of costs, and that would be a significant barrier to early stage companies and would ultimately hinder innovation, we think. They're great standards, they really are. My company, I can tell you, doesn't meet a single one of them, though. It's a very high bar. So we decided that's probably inappropriate, at least at all levels. Maybe as companies mature, that's appropriate. And the other area of confidentiality that we covered was whether encrypted systems, end-to-end encrypted systems, can sort of circumvent a lot of the issues around confidentiality and doing conflict checks. If you're able to build a system that has no possibility of data leakage from one client to another client, we were talking about, does that meet the need for separating? Does that meet the sort of firewall need there? We didn't get to this at all, but this is in the memo. We talked a little bit, or the memo talks a little bit about character review and the need for essentially doing a moral character review on companies, just like we do that for lawyers. And then the review process, which would be quite extensive, but not to the point of becoming a huge barrier, but extensive in its need to protect the public. So there's a balance there, and I think we got that pretty well.
Thank you, Daniel. I'll call on Judge Wendy Chang to summarize her assignment.
So we started looking at the other side of certification, which is what happens when someone violates certification or falls out of it. What would we be recommending that the other side of that system look like? So we evaluated the existing state bar disciplinary system and looked at it to see if it would be a good mirror for having a system to address, these companies that either they violate certification or what. So we had two prongs to how the discipline could be triggered. One is through the companies that certify and somehow do something wrong afterwards, or two, ones that aren't certified at all and are absolutely engaging in UPL. And the existing structure for addressing UPL is not very vociferously or aggressively pursued. It is a criminal remedy with the district attorney's office. The state bar it's not very clear what the state bar can do with respect to UPL as to non-lawyers. And so on that end, we were thinking about maybe recommending statutory change to give the state bar some type of jurisdiction to do that. I know there's fee issues, and you're smiling at me. There's a lot of issues that going on with, creating a system that is requesting more of the prosecution for the OCTC office, and we totally understand that. This is our wish list, and hopefully that the system can be set up in a way where there's enough funding, and either from the legislature or from the fees for applying for this certification that will fully fund what needs to be done on the discipline side of it, and that's what we're envisioning. On the cert side, we analyzed what we thought the level of discipline should be, and we think that fully modeling the existing attorney disciplinary system might be a little bit too much. It's a very complicated system with many, many levels. So we were thinking of maybe recommending a more simplified, less stepped version of that for, and then with the discipline being yanking of the certification. And so that's it. And our assignment is going to look at Randy's memo about applying any of this to the legal device world.
Thank you, Judge Chang. And so we had a great discussion after reviewing the assignments, and we haven't formed any recommendations yet at this stage, but our discussions led to 4 specific research assignments that we'll be undertaking for the next meeting. The first is to look into privacy by design approach for building these type of systems, and how does it allow a provider to maintain confidentiality while also allowing the AI system to use machine learning to improve itself. And then we all to explore what are if there are any cost barriers to this approach, and any conflict rules that would be impacted by this. So that's the first assignment, is privacy by design. The second assignment is to have a second look at the Legal Cloud Computing Association standards, which is identified in the previous assignment. We want to take a look at it, a second look at it, to see if it could form the foundation for whatever we would like to propose, whether there are relevant or parts from that, or some modifications so that we could use. So we'll look into that. The third assignment is to bring in law firms' perspective, and this is to gather feedback or experience from law firms on security standards that they're implementing or have been asked to implement. So we want to bring that voice in too. And finally, as Judge Chang said, we review the pros and cons for access and public protection for provider regulation versus legal advice device regulation. So those are the 4 assignments that we'll be looking at for the next meeting. And we hope that by next meeting, we can start putting together a skeletal structure for recommendations that we would like to form.
Wendy.
I wanted to just quickly, I'm going to circle back way back to, I think Justice Emmett did summarize my intent when I was asking about whether or not your committee was opposed to the certification requirement. The point is, if there's somebody on this committee who is very opposed to the idea that we are proposing, we're going to probably adjust how we're approaching it. That was all I meant.
Okay, anybody else from the committee want to weigh in on the summary or on any of the discussion? And if not, anybody want to talk about this? Joyce.
I just wanted to make a suggestion to Daniel. I was thinking about the privacy standards and the data standards. And I think one of the models that we sort of have been, that was discussed today in the ABS committee, was the idea of something sort of near term, midterm, long term. And I think that you could, for maturity's sake, take an MVP and say, there aren't any requirements, until you have a threshold of so many users or market share, or you could come up with some sort of threshold, and then different standards around data privacy, data protection, security. You could go through the whole gamut of those kinds of requirements and just make them kind of kick in as a product matures and as it takes over market share, just as a suggestion for a way to address that without being like, you don't want to have the bar be really high when you start and everybody's scrambling to kind of get the product out the door, but you don't want to necessarily leave it open either.
Yeah, we talked about that a little bit with respect to the LCCA and ISO standards, but I think it also makes sense to talk about that with the sort of maturity of privacy by design. Like anything, there are different levels that different steps you can take. It can be, different levels of paranoid about security and privacy, and I think that's appropriate depending on the use case, the maturity of the product. Yeah.
Well, and I really applaud your effort to attempt to adopt existing standards, to look around instead of creating something new and look to ones that already exist in the industry.
It's frankly just a lot easier.
Yes.
Derek.
When you're talking about enforcement, you mentioned state bar enforcement and criminal penalties, but I didn't hear you mention civil. And is that something that you discussed? And not only just as a injured client, because they may not have a valuable enough claim, under our current system to pursue that action, but maybe something kind of like a PAGA, where you have like which is the Private Attorney General's Act, where an individual can pursue something Did I say that wrong?
No,
Oh,
I
okay.
was just saying, literally, as we were having this conversation in the subcommittee, I thought, PAGA.
Yeah, yeah. So, you know, where someone else can pursue the claim, I don't know if, you know, class actions would be appropriate in that case, or, but something like that, or penalties where there's a serious fine, you know, attorney fee shifting for the attorneys pursuing it on behalf of the client. Is that something that you considered?
I think that's an excellent idea. We did not talk about it. I think it's good to put on the agenda for next time.
Johan?
Yeah. Sorry, I've been writhing in my seat for this little bit here. From the technology perspective, under the concept of protecting the citizens and improving access to justice, all these things that you're talking about requiring, they're all a breeze. Okay, PCI compliance is a problem. Nobody's processing credit cards without PCI compliance. The banks won't allow it, the credit cards won't allow it, nobody else will allow it. It's a moot point. Going to a higher level to something like HIPAA, standards for medical transactions or medical records and whatever, that's also standard. You can take it all the way to Department of Defense type work. I do a lot of secure work, and we literally plug in TLS encryption. I mean, it's not even on the table. We're taking care of that for you. Like that's out there. And I brought up the part where in our subcommittee, which I was told we're not going to go too deep into because that was part of your subcommittee, and I completely get it. I'll try and stay in my lane. Is if we completely suspend everything about antitrust laws, just for the sake of argument, the requirements you're placing are so beneath the scope and scale of what we're doing. To give you an idea, just in the United States, there are 58,359 different jurisdictions. Okay, so when I build a platform, I've got to account for every single one of those jurisdictions. So the idea of having an attorney, I'm sorry, I'm not saying it's your suggestion, you had mentioned it, that was in any way, shape, or form a controlling authority on what I'm producing, I don't think you're grasping the way the technology comes about. We start from infinity and drive down in scope, as opposed to when you guys think of scale, how do we do it, and then how do we replicate it and take it to scale? So the idea that which I have a product straight down this line that operates in all 58,000 plus jurisdictions, the idea that each jurisdiction, even if it were just state levels, would then require an appointed individual to be part of the process is completely untenable. It's not even on the table. It would shut down the innovation immediately. It just shuts it down. So when we come up with the products, and we have to be really clear here on what is delivering a legal service, and that's a big question. I get that, so I'm just kind of lumping it in. Is that we have the ability with the scale that we work at to do amazing things that attorneys can use. I don't like the term as a tool or a technology tool because it's not. It's more like what's happening right now is more like riding a wave. Okay, so you got to learn to surf. You got to sort of go with the flow a little bit here, as opposed to control it. Because if you fight the wave, you're never going to survive. And this is very relevant. I will suggest that in our subcommittee, we had quite a number of people. Well, quite a number of people. We had a few people who were we just didn't need new rules. We needed to leave it open. And everything we've learned from every other model, from the UK to Washington State to Oregon to Australia to India, which not a lot of people have brought up yet, the lesson that we've learned is leave it open. Open it up as far as you can, as wide as you can, as fast as you can, to get more people in with what Professor Hutchinson was talking about, the gig economy. And in some of those instances, attorneys will work in, through, and serve that greater entity, but it does not in any way, shape, or form is it going to be controlled on such a granular level. So I just want to suggest that we're at hugely different levels. And this is why I'm excited to be here, actually, because we need to bring it together in order to make these advances. One of the examples I used in our subcommittee was we've all been using online banking for over 20 years. Okay, the security's there. That's not even an issue. The market will very, very quickly, as it does in everything else in tech, get rid of those that aren't measuring up to the appropriate standards. I also think that as you heard my first question of the day, asking about the jurisdiction, I don't believe the bar does have the jurisdiction to go after firms, much less technology companies, in a superior fashion or from a position of superiority. So there needs to be a different nexus. Otherwise, it will literally stop why we're here, which is the access to justice issue. Respectfully.
Would it be your opinion we should just get rid of UPL? Like, just be done?
Actually, I think so. And the main reason for that is because of the lack of ability to enforce. It's passive and it's responsive, which is not effective by any means. Because, put it this way, if you were to find me in violation of UPL, by the time you got the process moving, I'd have one, changed, and two, created another couple of problems for you. Meaning we're moving at that speed. Am I on? Yes. And I think the appropriate action would, and I love what the bar is doing with posting things like UPL findings to LinkedIn, although I think that's going to turn around and bite us pretty darn quick with the right to be forgotten in the GDPR. But law enforcement and civil actions should be the way to go. If somebody, professes to be practicing law in any way, shape, or form, that can be fraud. That can be prosecuted. There's no two ways about that, especially if the client's unhappy or whatever the case may be. It's not a protected transaction. And in order to bring about that access to justice, and I'll refer back to the Washington model, which is back to the gig economy. We have a lot of people that find a lane and their entire industry is just in one lane, helping people fill out immigration paperwork, helping people file a mutually agreed upon divorce, things like that, which by its nature is at the low end of the market. And this isn't while it is the practice of law, it doesn't really abide the hypergamous nature of attorneys to be chasing the low dollar amount cases, which is where technology has the greatest yield, in that we deal with, when we don't deal with a single case, we deal with an entire docket of, say, 10,000 cases and blow through them like that. And so I don't want to hinder that ability. I'm not suggesting avoid the standards by any means. The biggest thing that kind of keys for me is that all of a sudden, and I will be preparing a demonstration for this, and I'll submit a video to the email on one project that I have. I literally could never run a particular platform with representations in all states. I can run a representation, or I can run a platform with 4 people, and it will serve the entire country. The entire country. I do not need one of those 4 people to be an attorney. Okay, sorry.
So
Daniel,
you covered a lot of ground, which is good. Those comments were really good, and you brought up some points that are really useful, things that we did discuss, and some things that we didn't. But just a couple of points of clarification. So we're not talking about TLS encryption. We're talking about end-to-end encryption. So this would be encryption that, and just for everybody else's benefit, this is encryption such that the provider does not hold the key, that this is encrypted essentially on device and sent, possibly stored by the provider, but only in an encrypted state. And then you essentially perform the machine learning inference or training on the device. So that's what we're talking about, not just the transport layer. And then with respect to requiring a lawyer on the team, that was a mechanism for competence. We don't want to hire 58,000 lawyers. That would absolutely kill any company, even a Fortune 500. Lawyers are just too expensive, right? So we just want to have one licensed attorney that's California licensed, that's saying, you know, okay, I think this is a good idea. That doesn't mean they have to be full-time. They're the one kind of doing the supervision. For a startup like mine, you know, maybe I go and find one on Upwork for $100 an hour, you know, and buy a few hours from them. It's not necessarily a full-time, you know, hire that's you know, horribly expensive. So, yeah. Anyway, there are a lot of more things, and I'd actually really encourage you to go through the report in detail. I think you'll have a lot of comments on it. I'll look forward to it. Yeah.
Further discussion? Okay, ABS.
So we started off reviewing some of the assignments that came in. With a special thank you to Kevin, who also kind of did dual duty with the report on 5.7, which was fabulously put together, and as well as Mark's assignment, which really kind of provided more of a short-term kind of view of things and ways that we can use current frameworks, specifically around the work that not-for-profit organizations already have scope to have non-lawyers perform some duties in California. After that discussion of those two assignments, we then went into a review of some of our recommendations that we made to everyone at large last meeting. And we all kind of looked at that and realized that we've grown up a lot since then and had thought about some new things that we wanted to include. So we ended up making some edits to those recommendations. We didn't vote to pass them because we were probably going to do that next meeting. But what I'd like to do now is kind of read through some of the reworked recommendations that we put together, which I think actually ties in a lot of some of the themes we've heard today so far. So one thing, and like I said, these are not formal because we didn't vote on them, but we will be voting on them next meeting, hopefully, is that we still feel that lawyers in traditional practice and firms will stay under the current regulatory framework with a mind towards expanding access to justice through innovation. That last bit about expanding with a mind towards expanding access to justice through innovation means we're open to different types of programs which would expand the ability perhaps out-of-state lawyers to come in and function easier, et cetera. That wasn't fully defined, but we wanted to include that. Now, this is where we started to kind of widen out. Last meeting, we recommended that we were going to be recommending an ABS type route forward over MDP. But what we realized is that ABS was actually a bit too kind of restrictive in and of itself. So we reworked that to say that we would recommend that we widen the scope of our charter to include entities which may or may not have lawyer ownership or operational management and or control. Meaning we may have entities existing which are, and some of our other recommendations will go into this, but that have no lawyer presence in them whatsoever. That would be delivering legal services or law-related services, which is obviously something that we would still have to define. The next recommendation, which builds on this, is that the state bar would regulate these entities, but its scope would cover the delivery of legal services as well as law-related services. The next recommendation is that this new model that we would be proposing would include both for-profit entities and would not be limited to not-for-profits. And the last recommendation we made was that all entities providing legal services would involve at least one lawyer in the organization authorized to practice in California to ensure a form of quality control now and adherence to regulation. And this is the key part, or another means of ensuring quality control over the legal product, device, or service. And what we meant by that is that they wouldn't necessarily have a full-time attorney on staff, but might be, as we've just heard, a possibility would be some sort of a few hours or whatever that may look like as a means to have a lawyer involved in a quality control capacity. So a couple of the differences we made just to highlight to the group, because you may all not be as excited about ABS and MDP as we are, is essentially we widened the scope of our recommendation where we said we're not just going to start thinking of through the lens of ABS and MDP. We're actually going to go outside of that and above and kind of include ABS or MDP, but also include the idea that we would open up the ability for entities that have zero lawyer ownership or operational management or control to operate and deliver legal services or law-related services. And then we also opened up a little bit the definition and kind of added clarity. We did say last time that we wanted to have an authorized lawyer involved in that entity, an authorized lawyer who is authorized practice in California involved, but we really meant from a quality control perspective, which may take on a little bit of a lightweight approach. And I do think we just heard from Johan some of the issues that we would get by being too heavy-handed with that regulation. And I think that's extremely important to keep in mind, especially as an entrepreneur in the space. In the early days, that sort of stipulation could be a really huge cost drain. So that's what we wanted to avoid. But we do want, and the reason why we included that was to ensure that at the end of the day, the end user of that device, product, service would be protected in that the quality would be up to a level that it would be deemed okay. So I can continue with some of our recommendations and our action items, but I'm not sure if you want, Chair, to have us discuss that, or should I continue? Continue?
Is there anybody wants to comment on what we've heard so far?
Okay.
Okay.
The next, we had a recommendation to bring Crispin Passmore in. Crispin Passmore was instrumental in the changing of the ABS regulations within the United Kingdom. We thought that it would be great to recommend to bring him in actually for the committee at large, the task force at large, but also if that wouldn't be feasible, we would be happy to bring him into one of our subcommittee meetings. And I think in either case, we would love to have our committee prepare questions for Crispin, but also have other subcommittees be open to providing questions around what the UK experience was, what was tracked, what wasn't, so that we can learn from that experience and kind of incorporate that in our recommendations moving forward. We had a few action items that were about kind of provision of different points of information for some assignments that are still ongoing. A new assignment that was assigned but is going to be, Mark is going to be taking on some kind of info gathering around entity regulations of law firms, very preliminary, early kind of work, some of which I think Mark has already prepared in the past. And then the questions that we have slated for future consideration of our subcommittee are twofold, and I think they also echo some of what we've heard already today. One is, how are we going to ensure that our suggestions have the intended result of furthering access to justice? And coming out of that, how do we track the effects of the changes that we're going to be proposing from an access to justice standpoint, and how are we going to gather that data? So I think we've also heard that from other subcommittees. We want to ensure that not only are we proposing that we are going to be making these changes, but ultimately to keep in mind that we want to ensure that we don't have any unintended consequences that will prevent access to justice, but also if we build into these processes ways to track us moving the needle from an access to justice standpoint. So that was us.
Daniel. Oh, sorry, Daniel. My process here, it just fell apart.
No worries.
Anybody else in the committee like to speak first to this issue?
I would. I wonder, based on the work that was done in this committee today and the comments that have been surfaced here recently, if it, there seems to me, I'm looking at Johan's level playing field solutions, and there might need to be in all of the subcommittees, or at least in the recommendations, a distinction made between software tools that are targeted to be services provided to law firms versus software tools that are really meant to be client-facing. When I think about the kind of work that I do in Florida for self-represented litigants, not anywhere on the scale or scope of level playing field. My responsibilities are just going to be vastly different. My jurisdictions are going to be smaller. I am going to have a lawyer as a subject matter expert to ensure, it's just like I'm going to have a clerk talk to me about the procedural requirements specific to every county, because I'm actually helping a self-represented litigant walk through litigation on their own. And so I just feel like in all these places, we seem to have these two very different perspectives, and that it might not make sense for that to somehow be articulated and brought forth in a more clear, defined, concise way. Because I feel like that some of this, it's like everybody's sort of talking a little bit at cross purposes, because I feel like they're coming from such vastly different perspectives. Thank you.
Thank you. Anybody else from the committee? Now, Daniel.
All right, we love process. So, Andrew, I think it's really great that you guys are planning to talk to Christian Passmore and sort of get the UK view on it. As our resident Canadian, I think, didn't Canada or Ontario also go through this kind of thing recently?
Yeah, it's my law BC, the Sharon Salter work out of the Civil Tribunal. I mean, there's all of those speakers are on my list to recommend, and I certainly would defer to you if you have additional.
Oh, my sense is just they had a bit of a different sense and outcome than
we
UK.
didn't go fully ABS. Okay. There's aspects of MDP in different pockets, and there's aspects of ABS in other pockets. But in terms of a unified Canadian approach, although we are very generally a unified nation, we are not unified on that. But that's why California, my adopted homeland, we will be unified. So I'm looking forward to that. So. But that being said, I can also look through who might be other kind of folks to bring in. But we had actually one of the members of our subcommittee, Bridget, actually one of the materials that she put together was various names of folks who we also can bring in. And I think Johan mentioned the experience in India, which maybe you can send me via with the ATILS kind of email as well. Anyone there that would be able to share some of that experience. I think all subcommittees could benefit from learning from the mistakes as well as the wins that those jurisdictions went through.
Good. Other comments? You did talk about your assignments, right?
Yeah, so in terms of our assignments, we really just have one true assignment, and that's Mark, who's going to be putting together some information around entity regulation of law firms. I will share this, not to skew other subcommittees in the way you're thinking about things, but I think it was very helpful. Mark kind of had this idea where we should perhaps look at short-term recommendations, midterm and long-term recommendations, and structuring it as to what can immediately perhaps go into effect, what would take longer. And I think that we really love that, just because even from the opening comments when we started this task force, I think we are hyper aware of the fact that the nation's looking at us, that many different jurisdictions around the world are looking at us. And if we come up with different ideas that aren't as actionable and things that would necessarily be low-hanging fruit, I think it would take away from the overall quality of our recommendations at the end. So just something for all subcommittees to put on your radar. Some of that might not be as exciting and as innovative as some of the longer-term plans, but I think we shouldn't miss those opportunities and recommendations as well.
Yeah,
Good idea. Kevin?
Mark's memo or his research that he's going to provide, is it going to be entity regulation as in law firm regulation, or is it more going to be broader than that?
My understanding is that it's going to be broader. Mark isn't here right now, but we can follow up with that as well.
Other comments?
This is
Go ahead.
This is Lori. So I just wanted to say that, keeping up with what all of the subcommittees are doing has been a little difficult. And I know in the last meeting I was very vocal, I think, about, Wild West, let's get rid of all the rules. But I really love Andrew's approach of recommendations. I think part of the reason that feels so necessary for someone like me is this really does feel like a huge task and a one-shot kind of deal. So I just would like to say I really appreciate and want to second the recommendation of an idea of beginning recommendations and then maybe, something a little later down the road and then ultimate goals. I think that may help relieve, at least in my opinion, some of the pressure those of us who don't sit in these spaces regularly might feel to make some real change.
If I can jump there, yeah, I totally agree with you. And I think one thing that was made evident in our meeting today is that there are a lot of different things that and kind of frameworks that already exist where we could move the needle of innovation to improve access to justice, and that we shouldn't ignore those and kind of miss the forest for the trees there. So I think hopefully in other subcommittees, there's probably been reference to some easy kind of wins about what already is in place and with some small tweaks, what we could do around that. And I think it's important for us as a task force to consider those as well.
Great suggestions. Joanna?
It also plays well into how the state bar is currently structured and how we're focusing on our strategic plan going forward. This report will have a preliminary idea what it's going to look like over the summer. Hopefully we'll be able to get some feedback early from the legislature and the Supreme Court as to ideas that they think would be something we should be pursuing, which would give the board a chance at its January meeting when we address our strategic planning to find out which of the recommendations should be adopted and how they fit into the strategic plan. If it's a goal, and then short-term and long-term objectives within the 5-year plan, it would really be helpful for us as a governing body to have it structured that way.
Great. Well done. I asked, anything else? I asked Randy if he could just spend a few minutes talking about the concept of a survey. We've talked for quite some time about putting together a survey, and I thought it would be helpful to sort of have some idea about where we're going and how we're going to develop that and when we're going to develop that. So Randy, maybe if you could speak to that.
Sure, we have a consultant who is rendering survey-related services to us in connection with another state bar project, the legal malpractice insurance project. And we are going to hook up with that staff person who's in charge of that group to find out exactly what the time frame is going to be in terms of creation of the survey subject matter, designing the survey questions and the outreach strategy, and then how long the survey period should run. We're hoping that we could develop all of that so that the survey will come back to us during that August meeting. Which means, according to our work plan, we are looking at the May meeting as being the meeting when the individual subcommittees start articulating their topics for what they would like to be surveyed. And we're not drafting the actual survey questions because that's what we pay the big bucks to the consultant to do, and to design how it's going to be scientifically valid in terms of what we get back. But there are certain topics that we're interested in. And so we're interested on different fronts, really. There is the provider front in terms of law firms and technologists, and trying to find out possibly what is their interest in playing in this space, or what is their source of reluctance in participating, because we have a report from Professor Henderson that says it's the rules and UPL that's the largest obstacle to having technologists and other entrepreneurs engage in developing new innovative delivery services. But it would be great if we actually had survey data come back from groups who have explored it or groups who tried it and then retreated from it, and have an actual set of data that says X number of survey respondents indicate that UPL is their obstacle to wanting to engage in these innovative delivery services. By the same token, we would also like to know from consumers. We would like to know from consumers perhaps whether or not their interest in using innovative delivery services depends on the participation of a lawyer, depends on some stamp of approval or licensing or certification of the provider, depends on the testing or reliability of the product itself. And what other consumer indicators are there that would suggest that the target beneficiaries of these access to justice improvements, whether or not we're not just speculating that they would use it, that they actually would. And so we would want each individual subcommittee to talk about these types of topics for survey questions, collect them up, deliver them to the consultant, have them develop the survey questions out for each plan, and again, hopefully time it so that it comes back to us in August. And that, combined with the public comment on the tentative report, is going to be a tall order for us to do in 2 meetings after the public comment period closes to refine that tentative report into a final report.
Wendy. Can you speak in your microphone?
Are you planning on reaching out to the trial courts who are serving the people with some of those questions?
I think we are in a position to give all sorts of ideas and recommendations to the consultant on how to outreach and get the data that we want. And so anything like that, how we should go about it, who should we be targeting, I think will be helpful. We're interested in all of that. I'm not sure how they proceeded with the legal malpractice in terms of determining the outreach strategy, if that was coming from Linda Katz and the group itself, or it was largely driven by the consultant.
Yeah, the consultant you're referring to is the University of Chicago, the National Opinion Research Center, and they have a very specified way of doing these type of surveys that involve panels. So it would not include, if we were going to include the trial courts, that's something we would need to take on ourselves. What we're getting through them is a really wonderful ability to engage the public. And you can sort of select your different types of panels that you're interested in because they have thousands of them set up all over the country. But if we wanted something as specific as trial courts, we'd need to augment the work that they would do with some additional type of survey, which would be fine.
Well, the only reason I mention it is because some of you know I sit in a limited jurisdiction court, and a large percentage of the people who appear in front of me, they are self-represented, and they talk to me, and I see what's going on, and I have an opinion on, and from hearing from them of what seems to be barriers, and so I don't think I'm the only judge that's seeing that. That's why.
I think, if I may, this survey and what we're hearing, this may be a really great, effective tool for all of us to really make use of all of our networks and potentially send that out. I'm not sure if that's possible, but being able to add maybe different contact points or whatever way we would go about doing that. But we heard this morning from Drew Amerson, who's at UC Hastings, who runs a legal tech incubator there, as well as some other programs. And I know in my network, I could get a whole bunch of different legal technology outfits who would be happy to provide that perspective. And amongst this room, I see leaders in a whole variety of different spaces. So unsure about that, but just something to keep in mind as you just heard of Judge Chang as well. I'm sure you know other judges who are facing kind of similar groups. And how could we maximize this survey to include our networks and maximize that? So just an idea.
Great. Any other questions for Randy about the survey? Bridget.
How does this relate to the access to the justice gap survey that you're doing, or is there any way to overlap with that?
Great question. NORC is doing that survey as well. We have a internal check-in meeting on this project on Tuesday. Randy, I'm just making a note to myself. So why don't we talk about that then? We can bring the Justice Gap Study questions there and take a look. Now that is designed to identify the legal, there is obviously a connection, thanks Bridget, the legal services needs of low and moderate income Californians, and looking at the gap between the needs that have been identified and the services that are available. Thinking about that and the Sandifer report and some of the issues that she really highlights, I think certainly we can incorporate questions that would be relevant to this working group into that NORC survey, and the timeline I think will work. So we'll discuss that internally as a staff group next week, and then Randy can communicate out with all of you.
Great, thank you. Bless you, bless you. Other comments about anything?
I just wanted to thank everyone who prepared anything from my subcommittee as well as all the other subcommittees. Just some fabulous work was put together, and I just think that it was a really wonderful experience, although it was a very long experience going through all the materials. I found myself extremely energized to show up today, and I think that was certainly a testament to some fabulous work from everyone, so just wanted to say thank you.
Thank you. I would second that. It was a huge amount of work that went into putting those materials together, and I'm very grateful that you all spent the time and effort that you did, and then to read it was also a challenge. So thank you all so much. We are going to get out a few minutes early. And I look forward to seeing all of you. But before I do that, let me just also say a thank you to our wonderful State Bar staff. They all do such a great job. You know that these meetings don't happen by themselves, and boy, they just keep us on track and keep us moving forward and remind us of those assignments and getting them done. So I thank all of you so much for your efforts as well. Travel safely to your homes, and I look forward to seeing you on April 8th. Thank you.
Just a second, I wanted to, just as a quick review, I mentioned to Neil that at some point I wanted to have us get together to go over what some of the tentative recommendations are gonna be. So